Good morning and welcome to the District of Columbia Court of Appeals. We apologize for the delay this morning. We were having some technical difficulties, as I'm sure you were aware, but we're going to get started a little bit late. And for anyone who is listening to us remotely, we are unable to live stream this, so we are just doing the audio for today. Thank you. First case on the calendar today is 23 CV 777 and 24 CV 562. Michael A. Sirocco versus MedStar Georgetown Medical Center, Inc. et al. Counsel, when you're ready, you can come to the podium, introduce yourself, and let us know how much time you'd like for rebuttal.
Thank you. Good morning. May it please the court, Patrick Senfley on behalf of the appellant, Michael Sirocco. I'd like to reserve 3 minutes for rebuttal. The first issue in this appeal is whether the appellant has established the proper foundation and basis that support the standard of care opinion of his liability expert, and more particularly that it's part of the national practice. We've identified Brian Holmes as our liability expert. Dr. Holmes is a board certified neurosurgeon with well qualified. Under our developing case law, all that's necessary to establish the proper foundation and basis is that there must be an inference from the testimony that the standard of care is within the national practice. One way to do that, which was done in this case, is that the basis, the foundation and basis can be established if an expert testifies that he has had discussions at national conferences. It gives him there's the inference raised that he's familiar, has knowledge of the national standard because he's gone to national conferences and discussed with professionals what the standard is and what's particularly for the certain medical procedure. Here, Dr. Holmes has laid a sufficient foundation and basis. In his report of September 13, 2021, he states, I regularly attended national neurosurgery conferences where spinal decompressive surgery, including laminectomy procedures, were discussed and reviewed. In the supplemental 26 disclosure, plaintiffs disclosed the basis of Dr. Holmes' opinion to include his regular attendance at National Neurosurgical Conference where consensus of the applicable standard of care for laminectomy procedures are reached and discussed. So the appellant respectfully submits that the trial court erred in this case on this issue because the court wanted more detail, like what specifically did you talk about at these conferences with respect to laminectomy that deals specifically with this case? And it put us at a greater hurdle than was necessary because all you need is an inference. So the court's very clear, one inference. And that we established among others with Dr. Holmes' testimony that he attended national conferences to discuss laminectomy procedures.
It is a little puzzling, though. You would think it wouldn't be that challenging, or I'm not quite sure what the downside would be, assuming the inference is warranted and in fact, in greater detail than is laid out in the materials you're describing, your expert could have said, and at those conferences, the consensus that was reached was that you need to remove all of the material to, barring unforeseen difficulties, you need to remove all the material to preclude or prevent nerve compression. If that's true, it would have been pretty easy to say. And what would the downside have been to say that? Why wouldn't you say that?
A lot of experts don't. When you go to conferences, there's discussions about laminectomy procedures. There's a neurosurgeon and that level of detail may not be specifically discussed, but there's still an inference raised that this guy knows what the national standard of care is. And the two cases that.
So make sure I follow. Are you saying that imagine what happened at trial was that your expert was put on the, assume there's a trial and your expert was put on the stand, and on cross, your expert says, we never really got very specific. I mean, I went to lots of conferences and we talked about laminectomies and people talked about national standards of care, but never really none of it ever waded into the details of what the standard of care is with respect to how much, tissue you should be removing in order to do an adequate laminectomy. It just never touched on that topic. Would you say that that evidence would be sufficient to support
Yeah,
a
yeah.
verdict in your favor? Because it seems like that would then refute the inference that you're saying can be drawn from the general materials that were
No,
provided.
The inference is really, no, it would not refute the inference. The inference, really what the case law and what the courts look for is the fact that he has knowledge. There is support for that opinion because the knowledge is grounded, the basis is grounded in the national standard of care. In other words, he's been to conferences and talked. There are cases like in Convent case, and I think the Coulter case, Convent dealt with plastic surgery, Coulter dealt with breast cancer. The court, both of those cases found in Convent, really the testimony was I go to national conferences and plastic surgery procedures are discussed. That was
Are
it.
you talking about that ruling there on summary judgment about whether there was enough to get to a jury, or are you talking about?
It was, I think, a directed verdict.
Yeah, directed
I
verdict.
think, but it was still fine as a matter of law. And same with Coulter. The only testimony in that case dealt
Right.
with breast cancer
Right.
was that there were breast cancer procedures that he
Right.
discussed.
It-
It wasn't that detailed.
Understood. And when the record is silent about whether you can infer from what was said that you're describing to some more specific knowledge that just wasn't expressly elicited, that's one thing. I was
Right.
postulating a slightly different hypothetical where actually it becomes clear on cross that the expert, whatever
Right.
discussions there were about national standard of care and laminectomies had nothing to do with, didn't relate to an assertion that the national standard of care with respect to laminectomies and removal of tissue is that you need to remove, barring other complications.
Right.
Paraphrasing, but barring other complications, you need
Right.
to remove enough tissue to prevent nerve compression. That just seems like it would be a tougher case than the case you were describing.
Well, again, all you need is an inference. And I think if there's
But
established,
the word inference seems to be maybe not the right word. It seems more like what you're saying is there just needs to be a very loose relationship between what the doctor says is the appropriate standard of care and the doctor's community or presence in the community of people who participate in national standard setting. I don't know. I'm not quite getting the inference point.
well, it's more than a loose association of the,
Because at the end of the day, it seems like what you're saying, and maybe I'm just repeating Judge McLeese, is that in fact, there's no obligation or expectation that the doctor is going to say, well, you need to remove so much tissue to do this appropriately within the national standard of care. And that's what doctors nationally agree to. You're just saying that's not required.
well, no, I think in the Coulter case comes to mind is that once the doctor established that he had knowledge, the basis of his knowledge for the national standard of care, which is at conferences, then I think it's a quote from Coulter that he can then testify what the national standard of care is. And when he testifies what the national standard of care is, he's getting into the specifics that you've got to take out. You got to take out the tissue that is compressing, bone and tissue that's compressing the nerve. So it is a foundational requirement. And certainly in cross-examination, you can
But
get
it- but-
into,
But discussing the national standard of care does not require an explication or a level of detail of this is what I discussed with other doctors at this national conference. And so it just seems like this kind of very amorphous, like, yeah, we talk about national standards of care vaguely. But then I'm gonna say, this is what's appropriate for this procedure.
right, but they
And there
talk about,
seems to be a disconnect.
they talk about national standard care for laminectomy procedures. It's
Right.
not, so there is some specificity there that he knows what goes on with the national standard of care. He has a basis of knowledge what goes on with the national standard of care because he's attended conferences and have discussed, procedures.
You know, in this case, your position is helped by the fact that one of the things put into the record was a textbook which talks about what the goals are of a laminectomy to remove enough tissue so an instrument can pass through unobstructed. I'm sure I didn't say that quite right,
Right.
but there is that. Let me focus you on another aspect of the opinion though, because part of Dr. Holmes's opinion is that how Dr. Nair breached the standard of care is that he didn't do a follow-up MRI promptly.
Right.
Do you think that the record here supports an inference that that is the national standard of care to do a follow-up MRI when the patient presents with the symptoms that your client presented with? And by that, I have in mind the 50% improvement notation at that second postoperative visit. Is there enough in the record to support an inference that doing a follow-up MRI was part of the national standard of care?
Again, I think the fact that he has had extensive experience and has had discussions about laminectomy procedures at national conferences, capsulated within that is an inference that he also knows about follow-up care and management. And in his report, he talks about how he's had experience with follow-up care and management. That's part of his opinions. But I think there's an inference that a jury can draw an inference from that. But again, reading the case law, it's an inference, and we have to construe things in favor of the appellant. And the case law, in both these cases, Convid and Coulter, they just did not get into
If that's the
details.
right standard, so this is really in part a question about how to understand the trial court's ruling. So with respect to the original laminectomy procedure, the trial court's ruling is the proffered expert's testimony is inadmissible. It doesn't meet admissibility requirements.
Right.
So I don't know that in assessing that, we're applying the sort of summary judgment standard and saying, view the evidence in the light most favorable. We're really reviewing an admissibility determination. Do you agree with that or disagree with that?
Well, no, I think on the standard of care or standard of review, what happens is on admissibility, you have abuse of discretion, then summary judgment is de novo.
Right, but summary judgment follows automatically on that issue.
Right.
If the trial, I think it wouldn't always, but in this case, I think it's undisputed. You need an expert
Right.
to get to the jury on that issue.
Right.
And so if the trial court made a correct admissibility ruling or an admissibility ruling that was within the trial court's discretion,
Right.
then I think summary judgment follows as a matter of law on that issue.
Right, but if the question is, what's the standard of review? The case, I think Strickland, Snyder, and also case Cardenas, 998 A second 303, talks about how the standard of review collapses upon itself. And at the end of the day, this court will apply a de novo standard. Because it's admissibility and also burden of, sufficiency of evidence, burden of proof, and that's what the case law says. I mean,
I found our cases quite confusing on this topic. So there are some cases that.
I know.
Yeah, so I find them quite confusing. But anyway, so I get that.
I do too.
Can I ask you the other half of it? So on the MRI ruling, the kind of prompt MRI ruling.
Right.
The trial court doesn't explicitly say that's an admissibility ruling. Do you understand it to be an admissibility ruling or instead
No.
I'm going to assume it's admissible and I'm just going to say no reasonable juror could take
Right.
it and get all the way to a verdict favorable to your client on the MRI theory of
Right.
liability?
No, I think it's a substantive ruling. In other words, that it's not admissibility, it's vague and therefore it's substantive and taking all inferences in favor of the appellant, what prompt, I don't think it is vague. I mean, prompt means at the last visit, you got to do it soon. The person was discharged, so there's no issue about when that period ends. So I think that's the substantive.
The trial, I'm sorry, were
No, go.
you done with your answer to that
Yes.
question? The trial court was concerned, well, what the trial court said was that Dr. Holmes was missing an opinion about that a follow-up, excuse me, follow-up MRI would have warranted a second surgery. That I think the trial court used the word speculative. It was speculative that a follow-up MRI would have led to another procedure that would have averted the harm in this case. What is your response to that?
Well-
Was that testimony speculative?
No, but I mean, first of all, it's causation. I don't think she got there technically, but Dr. Holmes has opined that because of the failure MRI, that was a cause for why the severely compressed nerves are not were not found, and then in turn that would have, if it had been a prompt operation, that would have made a difference. There was it really.
Well, I guess the
caused-
court thought it was speculative that a follow-up MRI would have led to a second surgery.
All right, but Dr. Holmes has opined that because that was not done, that was a cause for not discovery, and then that, and took away, took away the ability to have a second surgery, to correct a revision, a corrective surgery. In his report, I believe it is.
And the reason it took that opportunity away was what? I think he did address that. What did he say on that
Well,
subject?
because if the natural flow or inference from that is that if we discovered that these, there was still severe compression going on, that would have led to a surgery. The surgery obviously wasn't done, the revision, but I think there's enough inference of causation there to support that. I don't think there's a missing opinion.
Can I ask you a question about your brief, and in particular, whether you are presenting as a separate claim for relief, the trial court's denial of reconsideration with respect to the kind of supplemental affidavit from Dr. Holmes? I took a footnote at the end of your brief to be saying, I mean, your brief does say you're challenging the denial of reconsideration, but it seemed to be on pretty much the same issues as the original ruling. And I thought I took the footnote as indicating that you were not challenging the trial court's exercise of discretion in refusing to kind of add to the
Correct.
factual mix.
Correct.
The additional affidavit. Is that
Correct.
correct?
We're going on the summary judgment record. There's the report.
So you're not separately challenging the refusal to consider
No,
that on
we're not.
reconsideration?
We're
Thank you.
not. With the position that there's enough in the record to establish that we have had a proper, plan has provided proper foundation and basis.
Help me remember, there was there was this affidavit that Judge McLeese was asking about. There was also separately, there was a supplemental experts report, was there?
Yeah, the summary judgment record would be the initial report. It would be the supplemental 26 disclosure. It'd be Dr. Holmes' testimony. And there was also a summary judgment affidavit.
All right, and that supplemental disclosure came after his deposition, is that
It came
the
after
time?
was part of the motion for reconsideration. It was after the judge.
The affidavit was part of the motion for reconsideration, but the supplemental disclosure came when in time?
That came after the deposition. Just to kind of pull everything together.
But before the summary judgment ruling.
Correct.
And so there's no dispute that that is part of the summary judgment record, is that correct? To your understanding?
Correct, yes. It's only that supplemental affidavit for the motion for reconsideration. Any questions?
All right, council, we'll give you a little bit of time after we hear
Great,
from MedStar Georgetown.
great, thank you.
Thank you.
Good morning, and may it please the court. My name is Janet Ferrero. With me is Sean Gugerty, and together we represent the Appalachia Georgetown University Medical Hospital. So I think from the outset, we had two standard of care opinions, as this court has already recognized. One, interoperative with respect to the laminectomy procedure, and the second, postoperative with respect to the MRI. And with respect to both opinions, the trial court exercised her discretion to say that those opinions were inadmissible because one, Dr. Holmes in both cases failed to articulate a measurable standard of care. And two, Dr. Holmes failed to provide a factual basis for his opinion that the standard of care required Dr. Nair to do what he said. So I want to address Judge McLeese's comment first on the standard of review, because I think that's a very important threshold standard. And I don't think the case law is confusing. In fact, I think the case law cited by both parties makes it abundantly clear. And that is the decision to exclude an expert rests within the sound discretion of the trial court, something this court has uniformly respected. And the Russell Caldy case, the Coulter case, the Motorola case, all stand for that proposition. Then, as Judge McLeese pointed out, the decision to grant or deny a motion for summary judgment is a de novo ruling, but is one that is clear if the expert is excluded. And then the discussion of a motion for reconsideration is again within the sound discretion of the trial court.
So what do you say to your counsel on the other side saying these standards of review sort of collapse into a de novo standard of review?
I don't believe they collapse. Rather, Your Honor, I think that the threshold standard of review is an abuse of discretion standard with regard to the admissibility of Dr. Holmes's testimony, and I think that fails.
And do you think that it's clear that the court was using, exercising its discretion as to admissibility as to both opinions in this case?
I do indeed, because the court, in its order, while when it gets to the wherefore part, doesn't talk about this. It says in the body of its order a very clear outlined reasoning as to why each opinion should be excluded, and then says, and I am excluding those opinions.
Can you tell me where relative to the MRI, where in the order the trial court explicitly says I am excluding Dr. Holmes's opinion with respect to the MRI?
I don't have the opinion right in front of me. I'll ask my colleague to look at that while I continue with the court's permission. I wanted to address the laminectomy argument first, and specifically what this court has asked questions about how do you establish the national standard of care and what needs to be said about
Before
conferences.
you go to that, let me
Sure.
get back to the standard of review for a moment. As you've said that this is a matter of, that these rulings were a matter of trial court discretion, and yet our case law is also clear that a court erroneously exercises discretion if it makes a legal error, right? And if, for example, and I'm sure you would not agree with this, but if, for example, the court imposed an unduly rigid requirement with respect to how one invokes the national standard of care. If the court was too rigid as to that, or if the court overlooked testimony in the record, then one could conclude that that was legal error, and we review legal error de novo. That's why I think that sorting out the standard of review is not quite as simple and easy and clear cut as you suggest. You think there's no room here for looking at the court's admissibility ruling under a de novo standard of review, given that what was entailed here was looking at the expert's testimony, perhaps overlooking some aspects of it, perhaps failing to look at it in the light most favorable to the non-moving party, perhaps applying an overly rigid standard of how you get to the national standard of care. I'm just not convinced that abuse of discretion is really the operative standard here, and I'd like you to address that.
Thank you, Judge Thompson. What I would say is that as a general matter, this court can find that the Superior Court abused its discretion when there's a manifest wrongdoing on the part of the court. But in this case, that didn't happen because the court properly exercised her discretion and laid out the reasons she was exercising her discretion very clearly with respect first to the laminectomy opinion and then separately with respect to the MRI opinion. Her MRI opinion, and I don't mean to jump around, but her MRI opinion was based much more on the link to national sources than it was the national standard of care. Although she did say that Judge Holmes did not assert a national standard of care as to the performance of a post-op MRI. And in fact, we talked about these conferences and you asked Mr. Sefley about these conferences. And the court does require more than attendance at conferences. And I would respectfully refer this court to the Travers case, where the court talked about what was required with respect to conferences in particular. And there the court affirmed the trial court's granted judgment in favor of the hospital. So that was at the motion for judgment phase, a different phase than we are here. But what the court said is, yes, the expert said he attended conferences, but he never said how attendance at those conferences informed his standard of care opinion, his national standard of care. How does attendance at conferences establish a national standard of care? Because one of the things Dr. Holmes never told us, and we are left, and the jury would be left, more importantly, to speculate about, is what was discussed at those conferences. Mr. Sefley says definitely laminectomy was discussed, and that's great. But what about it? New techniques, new instruments, new pedicle screws, or we could guess
But
maybe a
doesn't
standard of care.
Our case law, doesn't our case law indicate that inferences can be drawn? I mean, at least at the summary judgment stage, right? I mean, I'm not sure that our case law reflects this distinction, but you could see at the summary judgment stage saying, look, this is enough to go to the jury. And then you get to ask all the questions that you just posited before this court. And if the expert can't come up with good answers, then maybe you can move for a directed verdict. But I'm not sure our case law allows for that. It seems like our case law is much more, to use a technical term, squishy about this national standard of care and what is required to satisfy it.
So I disagree that the case law is, and I love your term squishy, but I do agree with you that there are some circumstances in which you said was true. But in this case, that's not the circumstance, because here, like in the Travers opinion, Dr. Holmes doesn't tell us what about the Bayesian textbook establishes a national standard of care, and especially in light of the fact that on its face, the Bayesian textbook says it is our technique. Dr. Holmes never tells us what was discussed at national conferences other than the broad topic of laminectomy. So here we have a situation where we're missing two things. We're missing a description with regard to both the MRI and the laminectomy procedure as to what is the national standard of care. We don't know. Because I'll talk about the laminectomy procedure just as an example. Dr. Holmes says, you completely decompress, but there are occasions in my own practice when I have not completely decompressed, and that wasn't a violation in the standard of care. And in fact, not removing enough bone and tissue is not negligent in and of itself. And Dr. Holmes is an affidavit, his summary judgment affidavit. So, Your Honor, there were two affidavits. There was one in support of the summary judgment motion, which Judge Scott did indeed consider, and a second in support of the motion for reconsideration, which she did not consider. So there were really 3 or 4 bites at the apple here. But with regard to that affidavit, I think Dr. Holmes makes it very clear what his opinion is. And the affidavit establishes it's not enough. He says, and I'm going to quote for just a minute with the court's permission, a neurosurgeon, and this is the appendix, page 99, a neurosurgeon is not negligent as a general matter solely because the neurosurgeon leaves compressive bone and tissue in the operative field. So we know that. He goes on to say surgical circumstances may warrant the need to leave bone or tissue in the surgical field. He doesn't tell us what surgical circumstances, but he admits that surgical circumstances might warrant that. And then he goes on to say, however, not always, and I should really quote, however, a neurosurgeon is not always free of negligence by leaving compressive bone tissue simply as a matter of surgical judgment. So sometimes it's okay and sometimes it's not, but we have no standard by which to judge Dr. Nayer's conduct, which is what is at issue in this case.
Why, I wonder why a reasonable fact finder couldn't view all of that as essentially being the objective is to remove all compressive tissue. You should do that if you can. I'm not going to say you're negligent just because you didn't. Maybe there would be some special reason why you couldn't. But barring that, you would be negligent. And then if there isn't in front of the fact finder or hear the summary judgment decision maker about what reasonable fact finders could do on the record that would be before the hypothetical fact finder, if there isn't any indication that there was some special reason why in this case it was surgically indicated not to remove compressive material, then the upshot of that arguably to a reasonable fact finder would be, seems like there was negligence. Why isn't that a reasonable way that a fact finder could piece together the materials you're referring to?
I think in your hypothetical, Judge, that if the fact finder were a jury of neurosurgeons, maybe that could happen, but it's a jury of lay people. So they can't determine whether Dr. Nayer was supposed to remove all decompress all tissue and bone, or whether he encountered surgical circumstances that prevented that because Dr. Holmes didn't tell us. And so without Dr. Holmes saying out loud in his report or his affidavit or his deposition, all these opportunities to say it, he never said it. He never said it. So we don't have a standard that a jury of lay people can make the determination as to when it's okay and when it's
I
not.
think I get that line of thinking, and it just abstractly helped me.
Sorry.
Is this what you're saying? And if so, I'm wondering what your support is for saying it. But imagine that in a malpractice case, the plaintiff has an expert who will say, barring unusual circumstances, you should do X in a medical procedure. And that wasn't done here. If that's all that the expert says, I gather your point is can't get to a jury because even if there's no evidence of extraordinary circumstances that seems to be floating around, unless the expert also says, and by the way here, my judgment is looking at the records here, there weren't unusual or extraordinary circumstances of a kind that would have justified and rendered non-negligent the failure to do the thing that ordinarily you should do. Is that your abstract?
So
point,
let me answer that with a hypothetical, if I may, because I think there are circumstances where what you're saying is true, and this case is not one of them. Let's say a doctor is going out to perform a hysterectomy, right? And his goal and his obligation is to remove the entire uterus, and he doesn't remove the entire uterus, he leaves half of it behind. I think that a jury could infer by leaving half of the uterus behind without an explanation is negligent. But in this case, we have Dr. Holmes who tells us, there have been occasions in my career that I've left compressive bone and tissue behind. And I later discovered that I did that, but no, I wasn't negligent. So the jury is left to speculate as to when it is negligent.
I just want to make sure I understand. I don't quite, not to contradict you, but just say off the top of my head, I didn't quite remember that Dr. Holmes said that. You're saying that Dr. Holmes's testimony, I definitely remember the testimony that sometimes it is left behind, but that I just didn't remember the nuance you're adding, that sometimes he didn't even know he'd left it behind. And later he finds out, oh, I thought I had everything, but I didn't. And that might not be negligent because you might have done the best you could, basically thinking you had cleared everything out and you didn't. But your recollection or belief is that Dr. Holmes acknowledged that sometimes you're trying to remove all decompressive material you think you have, you weren't negligent in that belief, but you later discover that not reasonably discoverable by you hadn't. That's your belief about what his testimony was?
And Judge McLeese, I would encourage you to go back to the appendix at pages 110 through 113, where absolutely that is exactly what Dr. Holmes says. So I'm out of
But can I
time.
just get back to your hypothetical, which seems different than the testimony that you're pinpointing here? Because it seems like what we have here is a doctor saying, well, sometimes when, a woman has this condition, you need to remove the whole uterus, but sometimes you can remove half the uterus. And either are okay, it just depends on the surgical circumstances. Isn't that the close, you're pointing us to the record seems to take us afield of sort of what's more analogous to this case.
Right, and my hypothetical that I threw out was a little bit different because I said, the expert said you remove the whole uterus, which you do in hysterectomy. Whereas in laminectomy, you don't necessarily. And that's what Dr. Holmes admitted. And then he never said where Dr. Nair went wrong. He
But I
never-
feel like you're taking part of his testimony because he goes on to say, if you get to the second postoperative visit and you have a 45-year-old who's exhibiting these symptoms, he has only 50% improvement. This is not what you expect in a person of that age. You need to do something. You need to follow up with an MRI, which would have shown you, oh, you really didn't remove enough of the material. Now you need to remove more. So I feel like he didn't stop at, I mean, I read his testimony as saying it is not negligence per se not to remove all of it because there could be reasons for not doing it. Could be that you just erred in your judgment. You tried, you didn't get it all. But if you see down the road a piece that the patient has not gotten relief, then you need to do something else. And I just wonder if it's fair to pick apart the pieces of his testimony in the way that you're doing.
I believe it is absolutely fair because one thing that Dr. Holmes criticizes is what decisions were made intraoperatively. And that is separate and apart from what was done postoperatively. The only allegation with respect to that second postoperative visit is that sometime thereafter, or in the time frame of that an MRI should have been performed. And Dr. Holmes was very clear, not on that day, not on November 17th, but sometime in the realm of time.
Promptly, he said, promptly.
He used the word promptly in his subsequent affidavit. He used the word realm of time in his deposition. He used the word around that time at some other point. But he says around that time, which is not precise. It's very general.
It's not precise, but he did say that, I mean, he noted that, I think he noted that the doctor discharged Mr. Sirocco from care after that second postoperative visit. So basically what he was saying, it seems to me, is that it fell below the standard of care to discharge the patient with the symptoms that he had without doing a follow-up MRI. That doesn't seem unduly vague, or as the trial court said.
And I so appreciate that question, Your Honor, because respectfully, the record is clear that Dr. Nair did not discharge the patient. And I would refer you to the abstract at page 211 and ask you to read that note. Because at the end of the note, during the note, Dr. Nair is talking about the patients having paresthesia, and that's in there. And Dr. Holmes thinks the reason for the paresthesia is that the patient's wearing his belt too tight. So he says, you need to loosen your belt. And I would be happy to see him in the future if the need arises.
I remember that, but that sounds like discharge. So we're done, but if the need arises, come back and see me.
I don't think there's anything in that note that suggests he's discharging the
But even
patient.
if it's not discharge, if the expert's view is that given the symptoms that were being displayed in, I think it was the November appointment, I forget the exact.
November
date,
17th, yes, sir.
That the national standard of care would require a prompt MRI to figure out like, why is this still happening? Even if one of your clients didn't discharge the patient, it is undisputed that that one of your clients never ordered an MRI promptly or otherwise, just that it never was a follow-up MRI. Is that correct or not correct?
Well, it is correct. My client never ordered an MRI, but what is also correct is Dr. Holmes didn't tell us when the window opened, when the first time an MRI was to be ordered, but it was sometime after November
And
17th.
why does that matter if, I mean, prompt is certainly an imprecise term. I get that line of thought. But if I mean, do you really think, again, simplifying this to a simpler situation, if in a malpractice case, an expert is going to come in and say, the medical standard of care is that something had to be done promptly after a particular event. And it was never done, 10 months go by and it wasn't done. Would you say, that could get to a jury, even though the word prompt is a little unclear, because a reasonable juror could say, I'm not 100% sure what prompt would always mean, but one thing that I can think is that to it not having done whatever, what the national standard of care requires to be done promptly, wasn't done for months and months and months. And in fact, in this case, was never done, ended up being done by other people quite a bit later. Well,
2
why
years
wouldn't you
later.
be able to, why wouldn't you be able to get to a jury in a case like that?
And again, I think it's because we have a jury of lay people. We have a circumstance where at the last postoperative visit on the 17th of November, Dr. Holmes says, no, you didn't, the national standard of care did not require you to order an MRI on that day. You needed to promptly, which as you say is not a very specific term, order it after. But he doesn't tell us what were the circumstances that were going to require that to be promptly ordered after. And what does promptly mean? Weeks,
So
months?
just to drill down into what you're saying, your point is that the doctor didn't say, Dr. Holmes didn't say he had to order an MRI on that day. And so when exactly would he have issued, like, if the patient doesn't come back in, then when would he have ordered the MRI? Is that sort of your point?
Why and when? Yes, Your Honor. So I am way out of time. I so appreciate this court taking additional time from me. I would ask, based upon the court's discretion in not admitting the two standard of care opinions, failing to articulate a measurable standard of care and failing to connect that to national sources, that this court, I respectfully ask, affirm the decision of the trial court. Thank you so much.
Thank you, counsel. We'll give you just a few minutes.
Thank you very much. First, starting with the standard of review, Carnes 998 A second 303 at 309. The trial court essentially collapsed the admissibility and sufficiency standards into one, recognizing that appellant had presented a single expert who, if unqualified to testify, could not, as a matter of law, satisfy the sufficiency standard. We therefore review the trial court's ruling on de novo. So I think that's a clear reading of the standard of review. Getting back to inference. In Phillips, 714 A second 768, our primary concern is it reasonable to infer from the testimony that the standard is nationally recognized? And then in Owari, Travers was an old case, and this case law really is developed. And sort of on this point, it's kind of percolated down to we've expanded our holdings in Travers and Hawes, recognizing that it was reasonable to infer from expert testimony that a medical standard is nationally recognized so long as the testimony presents a sufficient basis upon which it can be made, inference can be made. To jump around quickly, the hysterectomy example is very good because in this case, it wasn't like some little bit of tissue was removed. Dr. Holmes has opined that very little tissue was removed. What was left was severe compression by the facets on the nerves exiting. So it was not not a situation where a little bit was missed and because I couldn't find it or something like that. That's not this case.
But I understand that, but I guess, we step away from the hysterectomy because it is hard to imagine sort of half of a hysterectomy, but let's say, there's a cancer diagnosis and, there's cancer in someone's colon. And so you have to figure out, we need to do surgery. And surgery is definitely the standard of care to remove the cancer from the colon.
Right.
But the question is, how much of the colon do you remove? And if you just say, well, surgery is the national standard of care, and then the expert comes in and says, well, he didn't remove enough, of the colon, don't we need some sort of national standard of care to say, well, look, if the cancer has spread, X distance in the colon, then you need to remove X plus
Right.
2 to ensure that all the cancer is gone, right? I mean,
It's a good example to switch over to colon cancer. I mean, in other words, standard care is you've got to remove enough of the colon where you have the cancer present to simplify it. But in this case, in our case, in this case, you got to decompress the nerves. The literature says you got to make sure they're decompressed. But in this case, there was no exigent circumstances present, and the standard of care requires you to move the compressive tissue, just like the standard of care in a colon remove cancerous tissue. And we don't have a situation where there's an exception to the standard. Where in fact, Dr. Holmes, and what counsel referred to, he fairly says, I really can't, I find it hard to separate where you don't take out obviously compressed tissue that's doing obvious compression and still be not negligent. I find it hard to separate that scenario, but he did concede that it could happen. That's all he was saying. So
Well, but I mean,
but that seems to contradict the testimony, right? I mean, to go back to the colon example, it's like saying, well, the national standard of care is to remove X amount of the colon plus, some boundary, except that it's not negligent to not do that.
I didn't follow. It's not, no, he's saying that.
I mean, if you're saying what he said, and I don't have his words, top
Right.
of mind, but if his opinion was, well, you remove all of the tissue that's compressing the nerve, except that it's not negligent not to remove all of the tissue that's compressing the nerve. If that's his testimony, then that seems
No, that's not.
tautological and
No, that-
really hard to discern as standard of care.
That is illogical. What he's saying is that you have to remove the tissue that is compressing. And unless you've got some real good circumstance, why not? But the standard of care is to remove it.
I don't know that he specifically words it that way, although I'm not quite sure he words it specifically the alternative way. It's a little murky. Your opponent says, we look at these pages, the right way of reading his testimony is the goal is to remove all compressive tissue, if that's a reasonable way of speaking of it. But sometimes myself, I've gone in, I've tried to do that, and I have ended up finding out later that I didn't achieve that, and that might not have been negligent. And there are two possibilities on that. You're kind of focusing on one and your opponent's focusing on another, and I'm not sure he very clearly distinguishes
Well,
between them.
in his,
Just to be clear, the one that you're focusing on is sometimes I go in there and I see a problem and I know I'm leaving compressive tissue, but I make a surgical judgment that on balance, it would be worse to try to remove the
Right.
compressive tissue than to accept some of it and not accept the problems that would be created. So that's the example, that's more the picture you're painting is
right,
it's not always, sometimes you can't achieve your objectives. You go in and you realize it's not prudent to do that for other reasons.
right,
But the way your opponent is describing it is more, he's acknowledging that sometimes I go in and my objective is to remove all compressive tissue. And I am a good surgeon and I do my reasonable best to do that. And for reasons that weren't reasonably, a reasonable surgeon wouldn't have done any better. But sometimes I later discover that's what I wanted to do. I didn't achieve that. That wasn't because I was negligent. I was doing the best a person reasonably could
Right.
based on the picture that I had in front of me. And I found out that I wasn't perfect, but I wasn't negligent. I just wasn't perfect.
right,
That's the way your opponent is reading that testimony.
right.
And I'm not sure it clearly says that either. I think it's kind of murky as between those two.
I think it's not,
options.
I don't think it is murky with all due respect. I mean, I think what the Dr. Holmes is saying that he said in his affidavit very clear, you got to remove compressive tissue. There are circumstances where you may not, and he said they're not present in this case because there was severe compression. And the defendants has not offered, Dr. Holmes has not offered any reason for why he didn't remove a lot of compressive tissue, and the defense has not raised that as a defense. I'll stand on my papers. I think I've said enough. Thank you.
Thank you, counsel. We thank you both for your arguments today, and this case will be submitted. The next case on our calendar today, or the next trio, I should say, is 24 CB 460. Maya Gilliam versus DC Department of Forensic Sciences et al. 24 CB 404. Julia Washington versus DC Office of Employee Appeals et al. And 24 CB 462. Jacqueline Ruiz Reyes versus DC Department of Forensic Sciences et al. Council, whenever you're ready.
Good morning.
Do we have
Ru-
water up there for you?
I think I'll be okay. I've gotten it out of the way. My name is Ryan Griffin on behalf of the appellants in all three cases. I'm here with my colleague Emily Postman. Appellants are former attorneys of the Department of Forensic Sciences who were separated through a reduction in force. They challenged that RIF before the Office of Employee Appeals along with 7 of their colleagues, all of whom were represented by the same attorney appointed by their union. After OEA upheld the RIFs, appellants union authorized the same attorney to file petitions for review in the Superior Court. 2 months after those petitions were due, however, the attorney alerted the union's general counsel not only that she had missed the deadlines, but that she had never filed the petitions at all. At that point, the general counsel found new counsel for the former employees, who quickly filed the petitions along with motions to extend. In 7 of those 10 cases, the Superior Court granted the motions, finding that the deadline for petitioning is subject to tolling and that the petitioners had established excusable neglect necessary to do so. The other 3 cases are the ones in front of you today. In these 3 cases, the Superior Court held either that the deadline for petitioning is not subject to tolling, or alternatively, that even if it is, the petitioners had not established excusable neglect. Both of those conclusions are wrong. As to the deadline, paragraph I of Agency Review Rule 1 incorporates Civil Rule 6. And Civil Rule 6 says that as a general matter, deadlines may be extended upon a showing of excusable neglect. As to what this showing requires, it is a relatively low bar. As this court said in the Admasu v. 711 case, it merely requires good faith and some reasonable basis for noncompliance. Here, the appellant's basis was entirely reasonable. They had an attorney who had represented them for 2 years through the OEA process. In other words, at that point, she had a long track record of filing on their behalf. And equally importantly, she had all the information she needed from them to file a petition for review, which is, of course, just a review of the closed agency record in the Superior Court.
Do we know if your clients actually asked her to file a petition for review?
It's
Do you
not.
think that there was an obligation on their part to ask?
It's not specifically in the record that they made the ask, but what is in the record and what I think is sufficient is that the general counsel for their union authorized the attorney to do so. And so at that point, they all reasonably understood that that's what would happen. Again, this is the attorney who has been
When you say
representing
they
them for-
all reasonably understood, who do you mean?
The 3 appellants.
Is there anything in the record that indicates that the appellants were aware that the union had authorized an appeal?
That is not specifically in the declaration. But again, they
And
were
with apologies to being equivalent, it's not there at all, right? It's not, there's just nothing on that topic.
correct.
in the
They
declarations.
they put in all these 3 appellants and all 10 petitioners relied on the same declaration, which was a declaration from their union's general counsel explaining the circumstances through which they all filed late.
Well, I mean, partially explaining them in the sense of saying that I think pretty much the 2 things you've mentioned, which is, no appeal was timely noted, one had been authorized. I mean, is there any more about how it was that it was 3 months later that that nothing happened in those months?
No, the
That's all there is in the declaration is those two things, or is there something else? That
That's,
you would-
that's correct. The declaration does not speak to either why the original attorney did not file or why she came forward 2 months
Or
later.
what, if
It-
any, efforts your clients, what interest they had in pursuing an appeal during that period of time? What efforts, if any, they made to monitor or be diligent with respect to whether one had been timely filed. It's just silent on all of that.
That is correct. It is silent as to that. On those points, I do think it's important to note here again, though, that you referenced diligence, and diligence really is not something you can assess in the abstract, but something that is entirely dependent on the circumstances and what they reasonably call for.
Right, and
again-
which, I mean, in some ways, I think that point is unhelpful rather than helpful to you, because it might suggest that a declaration would have been more effective if it had actually laid out what those circumstances were as it related to each of the individual clients and what efforts, if any, they'd made. So, I mean, I take your point, but I wonder the extent to which it helps you or is unhelpful to you.
Well, I think it helps in two particular ways. One is, again, that the appellants reasonably believed that the attorney had everything she needed to file for them. This wasn't,
I mean, you say that, but we don't, they could have reasonably believed it. I think that might be true based on what little we know. But there is no declaration that in fact they believed it or reasonably believed it.
that is correct. There's no declaration. And again, I mean, to be honest, part of it is expediency. They came 2 months after the deadline and said, we need to file. And so they put together a single declaration that covered the same boat that all 10 of them were in and filed that within days. And
Can you explain to me, maybe the briefs discuss this, but I don't recall that they do, sort of what the legal relationship is, or what your client's ability was to pursue these claims before they sought review, right? I mean, they're doing this all through the union up until the point where they're represented by union counsel. Do they have the legal ability to pursue these claims individually or personally, or do they have to go through the union? Do you understand what I'm saying?
Sure.
What the legal constraints are on them up until this time when the lawyer doesn't seek review on their behalf, and sort of what their relationship is to that lawyer?
Well, they're all proceeding individually. It's 10 separate matters before OEA. And at some point, they moved to consolidate the matters in front of OEA because they were all similarly situated, and OEA said no. So they all proceeded individually. They had a lawyer who was appointed by the union, but they were not.
Did they
Proceeding through-
ask the union to appoint them counsel how did that, maybe the record doesn't show this, and maybe I'm asking for extra record material, in which case, never mind. But if it's in the record, I'm just sort of curious how it came to be that they had union counsel.
The record does not show that.
Okay.
Either initially for proceeding in front of OEA or for their petitions for review for the Superior Court. It just shows that the union appointed counsel and in the first instance, and authorized the attorney to continue representing them and petition for review in the.
It does show that the union authorized the lawyer to continue representation.
Correct. That is in the declaration in the record, which again comes from the union's general counsel.
And just
And in a similar vein, does the record tell us anything about whether or not your clients, the individuals, actually had a relationship with the lawyer who failed to file the appeal, or were they dealing solely with the general counsel of the union? Does it tell us that?
Well, I think all you can infer from the record on that point is that, excuse me, that lawyer was the one who represented them each in their individual cases in front of OEA, which again, took 2 years from the point at which they were separated from employment, which was October 2021, and then August 2023, when they got the initial OEA decisions from the administrative judge. So there's nothing else in the record about how they engaged with the counsel during that, but that was the counsel that represented each of them in their individual case during that period.
I mean, the reason for my question is that, there's some discussion about how in a situation like this, the client is sort of bound by the failings of their lawyer for purposes of whether or not there's excusable neglect. And I just wonder if that rule ought to apply any differently in a case where there is this general counsel, at least possibly in between them, such that maybe they didn't have the typical relationship with the lawyer, but we don't know the answer to that exactly.
Right. And I mean, if I can address your point a little bit more broadly, I do think it is important to look at how that rule fits into this case, but I don't think the fact that they're working through their union counsel changes that. I think what's important about that rule is two things. The first is that in the cases that the agency cites in their brief, they cite three cases, the Lynch and Long and Flax, I believe, are the three. All of those three cases are all post-judgment or post-conviction cases. Long is a relief from sentencing case. The other two are post-summary judgment issues. And so I think in all of those cases, the court is referencing the rule you said about imputing attorney conduct to a client, but it's also looking at the court's interest in post-judgment finality.
So
And that's
you're
something that's
suggesting
not
that
implicated in
there's a
this
different
context.
excusable neglect standard in, assuming an excusable neglect standard applies here, that there's a different excusable neglect standard depending on whether you're talking about a Rule 59 or Rule 60P motion as opposed to, let's say, the notice of appeal provision that's in our appellate Rule 4 or things like that. Because I don't know that our cases have explicitly suggested that excusable neglect takes on a different it's a different standard. Nor do I think if that's not your point, and instead your point is the standard may not generally be different, but the weight you give to one of the factors, which is or an element of one of the factors, which is adequacy of an explanation for failure to act timely. And an aspect of that is if you're blaming your lawyer, generally you're stuck with your lawyer's actions, except in extraordinary circumstances. I don't think we've ever said, as far as I'm aware, that principle operates differently depending on the context, like which rule and what procedural context we are in. That's, if we said something like that, or is that sort of your inference about how you could piece all this together?
It's more of my inference. So my answer is more of what you said the second time around. The standard is the same. Excusable neglect is excusable neglect. It's the pioneer factors. It's the balancing test. That's true in all cases. I believe that this question about whether you impute an attorney's conduct to a client specifically speaks to the reason for delay factor in the pioneer test. And as to how you put it in there, I do think the context matters. And to your answer, no, you have not said that directly. I'm inferring that from the fact that the three cases they cite are all post-judgment or post-conviction cases.
Fair enough, but if you're going to explain why the degree of finality that exists in the order that someone is untimely seeking to challenge should affect the operation of the idea that generally folks are stuck with the mistakes of their lawyers barring extraordinary circumstances, why the degree of finality should affect the weight to be given to that factor as opposed to being, part of some other general exercise of discretion. Why do you think it feeds into that? Because it isn't immediately apparent why it would feed into that particular component of one of the factors.
That's fair enough. I think I mean, I'm trying to map it as best as I can onto that because that is obviously an issue. But I do think in some sense, it's a question of what's at stake again. And this is a case initiating decision as opposed to a final decision. And so I think there's just in Lynch and in Flax, the court is looking at it and saying, we're holding you to what your attorney said, because if we don't, we're going to have to reopen discovery or revisit our own summary judgment decision or make some other substantial litigation change to the litigation that's already been or that's already done and gone. And
Just to be specific, what you just said seemed to imply that the way taken, literally seemed to imply that whether you were relying on the idea that generally people are stuck with the mistakes of their lawyers for purposes of excusable neglect. We said the reason we are doing that is because otherwise you would be kind of undoing things that are final. And again, I'm not so sure I remember seeing that in our cases. I know that that's sort of your gloss on them, which is a perfectly reasonable position to take. I'm not trying to, but I just want to make clear, you're not asserting that we've somewhere said the reason we hold folks generally responsible for the mistakes of their lawyers for this purpose is because if we didn't, then final judgments would be unduly overturned.
I mean, you're correct. I'm inferring it rather, I don't have specific language to point to, and I'm inferring it again from the nature of those three cases, but also from Civil Rule 6 itself. When you look at 6B1, which is the general provision that allows tolling, and then 6B2, which is the specific exceptions from that general rule. And those are for Rule 50 and 52 and 59 and 60 motions for new trial, judgment notwithstanding the verdict, relief from judgment. So I understand Rule 6 and looking at 6B1 and 6B2 to be premised on that same understanding that once the court issues a judgment, you're in a different circumstance than before it does. One other, if I can just follow up one other point. I mean, the other really important point on the imputing attorney conduct is that even to the extent it applies in this context, which I think is different, there is the well-recognized rule from Lynch and the various cases cited in Lynch that generally an attorney's gross negligence will not be imputed to the client, including where it's in violation of the implicit duty to devote reasonable time and effort to their matter. And again, this is coming from Lynch. It's also coming from, there's a couple of cases cited in Lynch. One of them is, I think the key one is Clark v. Moeller, which is a decision of this court, which says that an attorney's gross negligence is not imputed. And it's in some ways very similar here. In that case, the attorney told the client, don't worry, I'll take care of it in response to a lawsuit, and then just didn't do anything.
Well, again,
we
we don't have
don't have-
declarations that indicate that here, and right, we don't really know. And the declaration doesn't really even explain why it was that the union lawyer failed to do what the union lawyer was authorized to do in a timely way. That's not explained either as I recall in the declarations. That's just a fact that happened without a description of its circumstances beyond that it happened. Is that fair?
Correct. Our contention is that the client's actions were reasonable under the circumstances based on the facts
Right,
that
but
are.
just as you were suggesting that perhaps you could fall into an exception that relates to gross negligence, it seems unhelpful to that if the circumstances of the lawyer's failing aren't laid out in the declaration. I was also wondering, was the idea of falling within a gross negligence exception something that was presented previously? Is that something that's teed up in those terms? Or is that a point you're mostly making right now? I just don't really remember a discussion of this was gross negligence and here's why the record would.
No, it's a response to the cases cited by the agency, particularly the Lynch case and the cases that are cited therein. And I think, again, just to follow up on the first part of your question, I think you have the sufficient information to find that, because what we do know is that the attorney was assigned to, was authorized to file these petitions, that she had all the information she needed to do so. And not only did she not do that for 2 months, but she didn't tell anybody about it for 2 months.
Can I ask you just a framework question that I meant to ask earlier, which is, do you agree that our review of in one of the orders, in the Gilliam order, I think there was no alternative ruling about excusable neglect. So that's just, either it's available or it's not available. If it is available, then either we need to send it back or we need to determine ourselves as a matter of law what the answer is. In the other two, there were alternative rulings about excusable neglect, concluding that it was not shown. Do you agree that our review of that aspect of those orders is for abuse of discretion, or do you think some different standard review applies?
No, I disagree. I think you can actually review it de novo. And the reason I think that is that excusable neglect determination generally is a mixed question of law and of fact. It looks at whether, as a matter of law, whether the court looked at the pioneer factors correctly and understood them correctly, and then obviously applying them to the facts. In that situation, in the mixed question situation, your review of the ultimate legal conclusions to be drawn is de novo. And we have the case sites for that in our brief.
In the context of excusable neglect, or are you instead reasoning?
No, in the
more
context of
generally?
mixed questions of law and fact.
Yeah,
You-
and what about the authority with respect to excusable neglect itself and what we've said about our standard review?
Well, so just to finish that, I think in mixed questions, generally, you draw ultimate conclusions de novo. And here there is no, and yes, you would of course normally defer to findings of fact, but here there are no discretionary findings to defer to. There's no credibility, there's no competing testimony, there's.
Can I-
So,
why-
but to your answer your question about specifically these cases, there are two cases. In the Brewer case, you reversed a finding that tolling was unavailable and you remanded for the merits. And also in the Savage Bay v. La Petite Academy case, I believe that was the same result. I don't know that you specifically discussed it, but in both of those cases, it came up after an extension request was denied. And in both cases, you said that that excusable neglect was established and sent in at least as many words, and you sent it back for the merits.
Can I just ask you, you said that not only did this attorney not file petitions for review, but she didn't tell anyone about it for 2 months. Is that, where are you getting that fact?
Well, what's in the record is that she told the union's general counsel about it 2 months later. So these petitions for these three cases were due, I think it was October 30th and November 1st of 2023. And the declaration says that on January 5th, 2024, the attorney told me, the union general counsel, that she had not filed the petitions.
Right, but that's different than saying she didn't tell anyone about it. I mean, is there any evidence in the record that your clients were only communicating with the lawyer through the general counsel, or?
No, it's not identified one way or the other. And again, our contention would just be that it was reasonable under the circumstances, given that there was no need for them to have input into the filing and no need for them to participate in the petition for review proceeding once it was filed, right? Because again, it's a review on the papers of the closed agency record.
Although, well, for all we know from the declarations, it wasn't reasonable under the circumstances because in fact, there had been direct discussions with your clients and the lawyers, and they had said that the lawyer, some of them had said they didn't want an appeal, or they'd all been told that I'm not gonna be able to file it, even though I said I was, but we just don't know. So it's all kind of a black box, and maybe you can draw some inferences and say, well, it's kind of implausible that they didn't want an appeal, or that, but none of that is really spelled out in a declaration.
Fair enough that the record is limited. I can't argue otherwise on that, but I guess just one final comment on that. Again, this goes to one of the 4 pioneer factors. It goes to the reason for delay. And the Supreme Court in Pioneer and in all the cases applying Pioneer for decades now has said this is a true balancing test, and you look at all of the factors. And so here, you don't have to find that reason alone is sufficient for excusable neglect. They have a reason, and they have, I think, an understandable reason, whether or not you ultimately think it's sufficient on its own. But at the end of the day, I think you also need to look at the other 3 pioneer factors. And as we've explained in our brief, all 3 of those also cut in the appellant's favor here.
A few moments ago, you used the word tolling, equitable tolling, I guess you meant, and excusable neglect in the same sentence. What's this case about? Is it about excusable neglect or equitable tolling?
As I understand the relation between those two, equitable tolling is the general concept of the court exercising discretion over a deadline. When the court exercises that discretion, you have to decide what standard you use in exercising it. And we contend that the standard here is excusable neglect. And again, our view is that comes from Civil Rule 6, which says that. But it's also, I mean, even if you didn't look at Rule 6, I think you'd look to this court's earlier decisions in Brewer and in Mathis. And neither of those cases, I'm not sure that they use the term excusable neglect or pioneer, but if you read the analysis for tolling, it is effectively the pioneer excusable neglect analysis.
Thank you, Mr. Griffin. We'll let you sit down, catch your
Thank you.
breath. We'll hear from Ms. Johnson.
Good morning. May it please the court. These cases, the question of whether excusable neglect is applicable rests on pure textual analysis. And the employee's approach is exactly backwards. Whether Agency Rule 1B2 is extendable for good cause and excusable neglect rests on whether Rule 6B is incorporated into it, which rests on whether Rule Civil 6B is inconsistent with it. So in order to conduct that analysis, the court first has to figure out what Agency Rule 1 means. The employees are asking the court to first incorporate Rule 6B and then ask whether there's an inconsistency. And we just think that's exactly backwards. I think
Let's do it in the frontwards way then, as you see it. So Civil Rule 6 may or may not apply to Agency Rule 1. That's the issue here. But you would say that it does seem to apply to lots of civil rules. There are tons of other civil rules to which it directly applies. It accepts a few and applies to a lot. A lot of those rules that it applies to, that aren't accepted at least, so it seems like facially it applies to, have language that have deadlines that are worded with must. So you could find civil rule, pick one, but civil rule asterisk that has in it something must be done on a particular day. Do you think Civil Rule 6B, I think 6B, sorry, I'm on the wrong page here. The pertinent part of Civil Rule 6 is inconsistent with those rules?
no. So Rule 6B starts with whenever a rule says must or may, then Rule 6B, the good cause excusable neglect apply. So
Well, it doesn't quite say that. It says when an act may or must be done within a specified period.
that's more accurate language, but yes. So no, I don't think it's inconsistent. But the difference is.
So isn't, by parity of reasoning, the idea would be no more is it inconsistent with the agency rule, which says must, but it, is viewed as a gloss on it.
So I want to put this into a couple of different ways of looking at it. I think the first way of looking at it is that we have to start here with whether Rule 6B is incorporated in the first place. Rule 6B applies by its own terms to every civil rule. It doesn't have an unless it's inconsistent with Rule 6B.
Well, but if it
governs.
is inconsistent with it, if it was inconsistent with them,
Then there'd be an ambiguity.
then you'd have to figure out which trumped it all. And you're saying that it's just not inconsistent. One says must, and the other one says, notwithstanding a rule that seems to say must, there is an exception to those musts that is reflected here. And you're saying, no, those aren't inconsistent. There's a rule that says must and a rule that says sometimes must, doesn't have to be read as must, but could be read as excusable neglect forgiveness.
So here's the second side of
right,
how I wanted to explain this. That's sort of the first side, that we're starting with a question of whether there's inconsistency. And when you
Well,
read.
and I understand that, but
So-
right now, I'm not yet sure I understand why you think there is inconsistency in the
I
one side.
promise I'm getting there.
Okay.
So if you start with the question of, and Rule subsection I of Agency Rule 1 says, except we're inconsistent with this rule. And I would suggest that that invites this court to look at everything that comes before subsection I, at the rest of the rule, interpret that rule as a whole, including the comparison between Agency Rule 1B and Agency Rule E3. I'm sorry, B2 and E3. And that is where the inconsistency comes into play. That's the key to the district's argument, that there's just no other explanation. And I'll remind you that in
Just to be sure, so are you saying that if it weren't for E3 and the complications it poses to an incorporation theory, you wouldn't think there was inconsistency, and it's critical to your analysis that E3 creates an inconsistency that dictates the outcome here. Is that what you're saying?
Yes, yes, and that creates, at least, I mean, we think it's
And in
clear,
your
but
view,
we.
it creates an inconsistency because otherwise the good cause language in E3 is a superfluity.
You can put it under the superfluous canon. You could put it under the when things are written differently canon, which I think is actually even more helpful. The point is that the Rules Committee rewrote in 2019 B2 and E3 at the same time. They changed both of them. They changed the language with both of them. They were clearly looking at the two of them at the same time. And one of them says must be filed within 30 days. And the other one says must be filed within 30 days, except if it's extended for good cause. And we think that has to mean something. At the very least, we think that raises ambiguity. I mean, and that's when we start talking about policy and looking at how 6B is
So let's,
written.
can we talk about policy for a second? And one thing that just really flummoxes me is why we would say, well, you can't have excusable neglect when you're seeking to petition to review from the agency to Superior Court. But for sure, you could show excusable neglect if there was some delay in seeking a review from the Superior Court to this court in
Oh.
the same case.
I can explain that to
So,
you,
and-
yes.
And I believe your brief had an argument about how, time is of the essence and we need to get these things resolved. And yet there's just no question, I think,
So
that you could have this delay at a later stage in the case. So why would we have two different rules for the availability of excusable neglect?
So the excusable neglect under App Rule 4 is limited to 30 days. After 30 days, that's not available. And that's huge. The district isn't worried about an extra 30 days. The district is worried about an open-ended time, about the lack of finality. If the rule had said 60 days, that would not be as big of a deal. The point is that Rule 4 is limited to 30 days. There's no exception for that. So that's the key and the question here when it comes to finality. And if this court were to find that excusable neglect is available for sub B2 under Agency Rule 1, it would literally be the only rule of its kind, that's extendable for excusable neglect. Every other rule that involves level of finality has to come at least to the level of equitable tolling. Even statutes of limitations aren't extendable for excusable neglect. What we're looking at here.
I'm not sure I understand that. You mean that was unlimited in time? Because like the appeal rules allow excusable neglect to what seems like a final judgment. There is a judgment of the Superior Court. The time to appeal has run. Nobody has filed anything. It seems like it's a final judgment. And then someone comes along and says, well, excusable neglect, let's gear back up.
But some,
And that's, I mean, I take your point that is more limited in time than would be the case if there was incorporation here. But it is an analogous circumstance in which excusable neglect is available to some degree, notwithstanding what seems like a final judgment being at play.
So I don't find that analogous at all, because then everybody knows that Rule 4, that 30 days you're not necessarily final at 30 days. You have to wait another 30 days. But after that second 30 days has passed, if someone hasn't moved for an extension for excusable neglect, then you know that the judgment is final and it's not going to be disturbed. So what I'm suggesting is that if this court wants to, if there's any ambiguity, you start looking at how all the other rules are written. And if you look at Rule 6B, if you look at the types of things that are excluded from Rule 6B, it's a JNOV motion, it's new trials, it's amended judgments, it's relief from final judgment. And the employees, they're kind of talking both ways about this. They keep saying there's no prejudice in a delay because it's only a records review, it's only an appeal. And then they're trying to say, oh, but we haven't had our day in court yet. They have had their day in court. They have a final judgment from the, in this case, the OEA, but it could be any other administrative body. And that final judgment is the law if they don't appeal. And that finality really matters for the future. And especially now that agency rule has been extended. I mean, it was important enough under the CMPA, and I talked about that in my brief. But now we're talking about zoning decisions, or not zoning, but planning decisions and permitting decisions and liquor license decisions. What if somebody got a liquor license, did all their construction, and then a few months later, someone said, oh, I'm sorry, I missed my deadline. Don't explain why. And of course, that could go to prejudice. But prejudice doesn't give you finality. And indeed, in this case, 7 judges found, not 7 judges, but in 7 other employees, 5 other judges found excusable neglect here, and the district can't appeal that. So I just think I think it would be an astonishing extension of what is generally considered a very strict deadline.
Can I actually, just getting back to the legal argument you're making about incorporation or not, this is a legal argument too. It's a policy component if there's ambiguity, it would be an aspect of what you're saying, but back on just the structural point you were making, which is a legitimate complication that F3 has, agency rule 1F3 has
yeah.
a good cause provision in it. And I think in your brief, you refer to that as a superfluity. It seems to me that it's quite murky whether it's a superfluity because it seems to authorize all you need is good cause. And you don't have to, which would be less stringent than what if agency rule 1B incorporates agency rule 6, you might have to show, depending on when you filed your motion, good cause and excusable neglect. So it seems to me it's less a superfluity and more a confusing overlap that would require you to figure out which one governed if they're both potentially applicable. Do you see that point, or do you think it's really obviously a superfluity?
So I don't think it's obvious, but I think that I can help provide some clarity to it because I have put some thought into this. And the way I have seen it from looking at the way the rules are written is that good cause is generally an umbrella term under which excusable neglect is one type of good cause, because good cause considers all the circumstances. And if one of the circumstances is you missed your deadline, then you get into excusable neglect. And let me explain this under Rule 6B because I think it will help. If you look at Rule 6B itself, the easy way.
Just make sure before you get to structure, I spent a while trying to figure out the relationship between good cause and excusable neglect, because I do think it's relevant to understanding the structure of all of this. Are you saying that you think good cause is more or less stringent than excusable neglect?
So good cause is less stringent. Good cause before the deadline expires is less stringent than excusable neglect. But I think that once the deadline expires, the court uses good cause and excusable neglect interchangeably. They just apply the pioneer factors that include a requirement of articulating a reason for the delay. And I can give you some examples. I think Long is a good example. Long says that a good faith mistake is not good cause. So it's already talking about a mistake. And then it cites Lynch, and Lynch is an excusable neglect case. But again, I did want to talk a little bit about the structure of 6B because I think that's helpful as well. I think it's.
And just back, the question I wanted to ask you about it, the predicate was, is this a superfluity or is it more a confusing question about interaction? And the reason I ask that is because back to how Rule 6 interacts with the other provisions of the civil rules. Confusingly, they're not just a set of civil rules that have a must. And then you could say, well, Rule 6 says, although it looks like must, Rule 6 is telling you that those musts aren't really musts. They are musts subject to the requirements of good cause and or excusable neglect in the circumstances specified in Rule 6. But there are also there are several civil rules that have their own, that are not on the accepted list, that also have similar provisions that are worded in terms of good cause or that, and are different from what Rule 6 seems to say, which means one thing to me, which is that to the extent your point is, it doesn't make sense to have a rule that has something that is overlapping or confusing or maybe superfluous to Rule 6 to be part of what Rule 6 is applying to. That's a better point in theory than it seems to be in practice relative to the civil rules themselves, because the civil rules themselves have a bunch of examples that have that form.
So I'm going to agree with you there. When you go through all of the civil rules, there's a lot of them that include good cause, which would otherwise be superfluous. And so maybe surplusage wasn't the right word. Maybe what we're looking at is the Rossello standard, which says when there are two things that are written exactly the same way and then there's a difference, that difference means something. But, and that's where we're focusing on.
Although that point could be made about the civil rules, and maybe that means you think that on all those civil rules that have some language, I'm not sure what you think about how to reconcile the general good cause / excusable neglect model of Rule 6 with civil rules that seem, they're not accepted and that have musts, but then have some different only good cause or things like that. Do you have a view about how that should be reconciled? or
I
is that
don't. I
local
think you're gonna,
geography?
well, I think you're gonna have to look rule by rule. Some of them will say, but good cause, and then it's limited. And if it's limited, then the specific governs the general. There's gonna be like different canons for each one. I think the important thing here is that Agency Rule 1 pre-subsection I should be interpreted first as a whole before you look at inconsistency. And the other I did want to get to this point about Rule 6, because I think this is helpful. So
I'm
Rule-
sorry, can you just say that again? Agency rule 1 should be interpreted, 1B2 should be interpreted before we get to subsection I? Is that what you
Yes.
said?
Yes, absolutely.
But why wouldn't we read rule 1 as a whole?
Because the introductory prefatory clause to I is except where inconsistent with this rule. And if this rule included rule I, it would be entirely circular. Then you would say, well, first we incorporate and then we look at whether there's an inconsistency. No, if it's saying except where inconsistent with this rule, it's talking about everything that comes before. At least we think that's the most reasonable reading. And again, it's the question is not whether, like, if E3 were out on its own, we wouldn't say that there was a surplusage with, for example, we don't think that E3 does not incorporate a Rule 6B. We think it is consistent with it. The problem is that the drafters,
I think E3 is different from, well, it may or may not be depending on the relationship between good cause and excusable neglect.
but it's,
But E3 seems to just say all you need to do is show good cause.
well, and this was,
Whereas Rule 6 seems to say if you're making your motion after the time within which you were supposed to have acted has run, you have to show both good cause and excusable
So
neglect.
this
I
goes
do
back
think they
to-
are inconsistent.
no, this goes back to what I wanted to say about 6B being about good cause being more of an umbrella term. And if you look at 6B itself, it's really easy to look at 6B and say, oh, 6B1 must refer to good cause and 6B2 must refer to excusable neglect. But that is not how it is written. 6B as a whole, good cause.
So both 6B1 and 6B2 require good cause as a minimum, and 6B2 requires excusable neglect as an add-on of unspecified relationship to whatever good cause requires.
So, and I have a couple ways that you could look at it when you're applying that concept to the question of whether there could still be room for Agency Rule 1B2 to somehow be extendable for excusable neglect, but not good cause. And that is that good cause is a more lenient standard. If it's not extendable for good cause, why would it be extendable for excusable neglect? And honestly, if that was the rule, someone who knew 3 days before the deadline they weren't going to make the deadline would be like, oh, I guess I'll just wait for the deadline to pass because it's not extendable for a good cause, but it's extendable for excusable neglect. It's not the way this court does this. And I'll also note that throughout all of the civil rules, good cause shows up, even aside from Rule 6B.
Wait a minute, which did you say was the more lenient standard?
Good
Good cause. So why
yes.
would you wait to get under excusable neglect when that's the more stringent
So,
standard?
What I was suggesting was in response to Judge McLeese's question, which is if we take a literal comparison between B2 and E3, and E3 says except cannot be extended for, except unless good cause is shown. And so what we are arguing is that means that good cause is not an available excuse for B2. Otherwise it would have been written in there too.
Right, well, why doesn't it mean this? For intervention under E3, the court can extend the time for good cause, this broad term. All manner of reasons might be acceptable for extending the time to move to intervene. But Rule 6 as to motions made after time has expired subjects you to the more stringent excusable neglect standard, as to which E3 says nothing. In other words, the language in E3, I understand your argument that the reference to good cause in E3 suggests that we ought to read B1 as not accommodating good cause, as a must that can't be extended. But if you look at it in the way you described, which is that excusable neglect is much more stringent, it seems to me maybe you get to the point that E3 allows you to apply this really broad, loosey-goosey, will accept any good reason for intervention. But if you want to try to get out from under the must language of B2 as to a different time frame for appealing, you're stuck with what 6B1B says, which is that you gotta proceed under the more stringent excusable neglect standard. So it doesn't seem to conflict. I mean, I was following your argument, but it seems to me your concession that excusable neglect is more stringent kind of pulls the rug out from under that
I actually
argument.
think it's the opposite. I think that if you read B2 as precluding extensions for good cause, well, then they
For
necessarily.
mere good cause, I would say, yeah.
That they would, but if good cause isn't enough, how could excusable neglect, which is a higher standard, be enough to satisfy this?
You gotta
Excusable-
meet that higher standard. You can't say, you know, my grandma died or whatever reason you might come up with for good cause. You're gonna have to show a neglect that was excusable for some reason. You gotta meet both of those things.
So I'll step back and say again, like if we're at the point where we're talking about ambiguity like this, then we need to start talking policy and why this doesn't make sense. There's no other rule that's like that. There's no other rule where good cause wouldn't be enough, but excusable and neglect would be. And in fact, the rules, if you go through the rules and look at all of the good cause extensions that are in there that aren't 6B, that are
I'm
just
sorry,
sort of
say again,
peppered.
there's no other rule that says good cause wouldn't be enough and excusable neglect would be. Is that what you're
Correct.
saying?
I haven't.
Isn't rule 6B2 that? If
No,
you-
no, no,
if-
no,
if-
no, no.
If I have missed the deadline and I file my motion and I say I have good cause, I think the court would say, well, that's really interesting. And that means you aren't out at the beginning of 6B. But that's not enough. You have to make a more stringent showing of excusable neglect. So that would show
But if,
the existence of an excusable neglect add-on in B2 to what is up in the part in B before you get to the ones and the twos means that that's itself an example where good cause is not enough. And but if you can make that more difficult showing of excusable neglect, which is very counterintuitive to me, this is neither here nor there, but good cause sounds like I didn't do anything wrong as an original matter, and excusable neglect is like, well, I didn't do it right, but I have an excuse. And so the idea that the excusable neglect is more stringent is counterintuitive, but it does seem presupposed by the structure of Rule 6B, and although we've referred to them as cousins, which I don't find a helpful analogy, it seems the gist of our cases to think it is that excusable neglect is more stringent.
I mean,
But that is counterintuitive to me.
this court uses good cause and excusable neglect in excusable neglect cases interchangeably. Like, I will grant you that in good cause, this court doesn't even have good causes. I don't think there's been, it's very tricky, but I will say that, for example, Dorsey, which is a case we rely on heavily, uses good cause all the time, but it's applying excusable neglect standards. And I don't want to get lost in the weeds here, because the point is that, and I definitely want to get to excusable neglect. So let me wrap this up briefly and then I'll go quickly to that. The point is that if there's confusion about why the drafters wrote it this way or what they meant, then you start looking at all of the other rules out there. And there are no other deadlines to appeal that are extendable for excusable neglect. In particular,
I thought Rule 4 is a deadline.
30 days. I'm sorry, I'm excluding that because 30 days, just call it a 60-day deadline instead. That's fine. But I'm talking about extendable beyond some specified finality date. And so if you look at, for example, Rule 15, which the drafters meant to incorporate when they did Rule 1, Rule 15 explicitly says excusable neglect doesn't apply to this rule. I'm going to move on to excusable neglect. I apologize. I appreciate the court's indulgence. There's a few things I really want to clarify here. And I think the most important one is that the attorney that's named as the attorney in the declaration is Susik's subordinate. Like, this is all one law firm, essentially. These are the general counsel's office for the union. So when Susik says that she doesn't say she appointed an attorney or hired an attorney for the lawyers. She says she assigned this to her subordinate. And I think that's important because if you read the briefing in the affidavits, it's kind of trying to draw like some distance between them. Like, we couldn't possibly have asked the lawyer why she made the mistake. She worked for the union and she continued to work for the union several months after these petitions for review were filed.
We step back for a second. That your opponent is arguing that our review is de novo, and I'm interested in your response to that because I think your position is otherwise. But what do you make of your opponent's explanation of why our review really should be de novo here. I
I
mean,
mean-
obviously on the question of how to interpret whether excusable neglect is available, that's a de novo rule interpretation question. But on the question of a trial court's looking at a particular record and saying, I do or I don't find excusable neglect based on the balancing of the pioneer factors, your view is abuse of discretion?
Absolutely. I mean, first of all, excusable neglect was not an issue in Brewer. Brewer is an equitable tolling case, didn't talk about excusable neglect, and also doesn't say that there's no discretion. So we'll leave that aside. They didn't even reach the question. And the only other case the employees cite is Savage Bay, and Savage Bay applies discretion. It finds that the administrative law judge abused discretion. Now, there might be some situation where there's a question of law underlying an excusable neglect thing, and it's a pure question of law that this court would consider de novo, but nothing here reaches that point. And frankly, even when you're doing that, that's still under the abuse of discretion standard. It's just that, you know, if it's a violation, if it's contrary to law, it is an abuse of discretion. So
Here's another threshold question. In Ms. Gilliam's case, the trial court relied solely on the unavailability of excusable neglect. So if it's a discretionary determination, ordinarily, if we were to conclude that excusable neglect is available and disagree with the trial court on that point, ordinarily, we would send the matter back for an exercise of discretion. Do you think that we shouldn't do that because there's only one possible answer? Or do you agree that we should send the matter back for an exercise of discretion if we think equitable excusable neglect is available?
we think that in this case, the employees have not established excusable neglect as a matter of law, and that any judge finding otherwise has abused discretion. And we're basing this on Dorsey, and Dorsey's, again, that holding is repeated in Thompson, so it's not just a one-time case. And in Dorsey, this court said, without some explanation for the failure, the court is obligated to deny. And it says only after some explanation is given does the door open for any balancing of the equities. The employees don't
Well, there is
dispute
an
this.
explanation here. There's a question that then you have to get into other doctrines of how well that explanation works on this record or with respect to mistakes of counsel as a possible kind of explanation. But there
So-
is an explanation offered for sure.
I don't think there is. I mean, I would contend, the only thing that is offered is that the filings were not made in time.
Well, I just wanted to get back to the point that you had focused on that I had not, which is that the declaration of Ms. I hesitate to try to pronounce her last name, because I don't want to mess it up. But the declaration that we have from the general counsel says that she assigned the lawyer to appellants. And then she directed them to file petitions for review.
It doesn't
I-
say she directed them. It says she
Well, she
authorized them.
authorized
And I think that's very different. I could be authorized to use my own judgment. I mean, authorization means you can spend union money on this. It doesn't necessarily mean you've been instructed to do so. And given the importance of this, I think that's a pretty telling statement. In fact, it could be, I authorize you to do this if the employees want you to.
Well,
And
she doesn't say that. I
she
mean,
doesn't say either. She just says authorized. And she's supervising the
I
attorney.
guess
who-
I just wonder, could you read this with the flavor of we're in charge, we've given them lawyers. You know, I appointed one of my staff to do this. I authorized them to proceed with the appeal and they didn't do it. And it seems to, you know, you could read that as we've kind of cut them out of the picture. We're running the show. I authorized my employee to do this. They didn't do it. And so I immediately sought new counsel, seemingly indicating, well, I authorized her to do it. She didn't do it. That's a screw up. She should have done it. I authorized her to. You don't think that we can read this declaration in that way?
I mean, I want to separate two things. I don't think authorized means that it was a mistake. But I also don't think that if it said I instructed, that would be enough to constitute an excuse. That is simply the violation. And I don't think the fact of a violation of a rule can constitute
but
some excuse.
Just to pause right there. I mean, I guess it would be interesting though, if the individuals, the appellants here had an attorney-client relationship with the lawyer, and yet you have the lawyer being employed by the general counsel. And if the general counsel had said, I told the lawyer to do it, and then the lawyer didn't do it, that sets up sort of a strange situation of who's calling the shots, who has the attorney-client relationship, where does the duty of loyalty lie? And I just wonder whether that would be enough. I take it your point is I authorized is not the same thing as I instructed. But if we think I authorized the lawyer to do this, followed by paragraph 7 saying, you know, when I found out that I didn't do it, I got a new person on the case. I just wonder if that could be sufficient. Do you
I
thi-
mean,
I think
I don't think it comes anywhere near being sufficient. Everyone who is seeking an excusable neglect finding has failed to satisfy the rule.
Well, what about, the point that, wait, we're just applying this multi-factor test. So, what the declaration shows, it certainly raises some real questions about what's going on. And if you take into account the other factors, you could reach an excusable neglect determination.
So I don't think you can start by saying that there's any explanation here. Again, and I think that it wouldn't be enough if it said instructed, but if you think that there's wiggle room there, it doesn't say instructed, it said authorized. And not appealing something is not necessarily a mistake. It's not. Our office doesn't appeal things all the time because we think it's not worth our efforts, and someone could be authorized to use their own judgment or authorized to ask the client whether they think that they should appeal. So they have not even shown a mistake. let
That's true,
alone
but
an
it does sort of
excusable.
imply that, I take your point about authorized versus instructed, but the affidavit implies that when I learned of this 2 months later and found it hadn't been done, I took quick action. So it implies that there was an instruction. But I must say, it also implies to me, why did you wait 2 months before you checked to see if it had been filed, which doesn't do much to establish excusable, if you ask me.
I think if a law firm came before you and the partner said, oh, well, I authorized this lower ranking attorney to do this, but then the partner doesn't assume any responsibility for making sure that it happened, something like that. And I'll also note that a lot could have happened in those 2 months. Maybe some employee changed their mind. Maybe they said, oh, the conversation with the attorney went differently. Maybe, we don't know what happened because
Well, maybe
there's-
it does raise a question, though, of whether or not there was gross negligence. I mean, when you say as a matter of law, there was no excusable neglect, the facts at least raise questions about these other things,
I don't-
such as whether somebody was grossly negligent.
Well, the employees had the burden of proof here, and the excuse that they were trying to move quickly doesn't make any sense at all. They filed reply briefs. They could have filed affidavits from their clients with those if they were in such a hurry. And honestly, Susick could have said more in her declaration. She's the one representing these people. She's the one representing the union. I don't know why she had to hire outside counsel, except for, I don't want to get into that. But I think it's interesting that then she scrambled to hire outside counsel when the attorney worked under her and continued to work under her. And that's not in the record, by the way, go and be clear after
Okay,
this.
But
So-
the more you talk about the hiring outside counsel and this lawyer working under her, that sort of raises more red flags for me about something went awry inside the general counsel's office, and she could not rely on her own staff to do the work that they were supposed to be doing for these union members.
So then we go to the second prong, because I think that this is important. The relied on my attorney reason, which is the reason that is given. That's the only reason that
Well, it sort of relied on my union right?
Well, it's their attorneys. I wanted to answer this. This is in answer to your question earlier. So OEA appeals cannot be brought by the union. They are brought by the individuals. The individuals can choose to have the union represent them, or they can choose their own counsel. They could switch at any time. So the union's only relationship here to the employees is that they hired counsel. Well, they used their in-house counsel to represent them. Just to answer that question. So in order to use the I relied on my attorney excuse, which Pioneer says is not in itself excusable neglect. Pioneer says that. Then there's the two-prong test under Lynch and Long. And the first prong is that the action was outrageously contrary to the express instructions or implicit duty. And in this case, it's neither. There's no express instructions. We certainly don't know that by the client. We don't know that. We don't know if the clients talked to the lawyers at all during any of this litigation. And then there's also no implicit duty to appeal. Appeals it's not like your duty to pursue a case once you've brought a case in court. A final judgment has been reached. Whether you appeal, it could be a judgment call. But beyond that, there's a second prong. And the second prong is that the client themselves, the individual employees, are diligent in pursuing the claim. And without a declaration from them or any indication of their relationship with their lawyers, this is really hard to pull. I actually looked when we were talking about their involvement in the OEA at the joint appendix, just to see from the initial decision, it doesn't look like the employees even testified in the OEA. So we don't know how often they talked to their lawyers during those 2 years, if at all. They may well have just asked their union to do what they can for us and walked away from it. We don't know. We don't know when they spoke with their attorneys, if ever. We don't know whether they asked their attorneys to appeal. We don't know whether they knew that SUSIC had authorized an appeal, and we don't know whether they tracked the status of their cases in the OEA. What we don't know is staggering here. And I want to leave the court with this. The reason why these cases almost never percolate up to this court is because the excusable neglect standard doesn't tend to apply when it really matters, right? The excusable neglect and good cause standards are cabined by Rule 6b to the sort of within litigation deadlines, not the deadlines to bring the case in the first place, not the deadline to take it to another forum, not even the deadlines after a judgment is reached. And the problem here is that we're looking at a situation where on the same declaration, we have a handful of judges who found excusable neglect and a few judges who didn't, and yet it's exactly the same evidence. And so I'm just going to pull this right back to the policy question. This is one of the reasons we think that the drafters could not have possibly intended to leave something so important as the deadline for a petition to appeal, essentially, to such a broad, loose standard that could be applied different ways by the judges.
Before you get away, I would like to ask a question about a different of the pioneer factors, prejudice, because it's another inconsistency between the orders of the Superior Court, that in the Washington order, the trial court found that the prejudice factor favored the district, whereas in the Ruiz-Reyes order, the trial court found that there was no prejudice to the district. I guess I found the discussion in Washington of prejudice to the district very abstract. It seemed to take the form more of risk of prejudice, which is these deadlines can be important. They're intended to structure things so that there's finality, and then actions by agencies can be taken on a predicate of finality. But it did seem entirely lacking in any concrete showing of prejudice. So if assume for a moment that I'm unpersuaded that that factor really did favor the district, and then instead I think maybe the judge in the Ruiz-Reyes case had it better, that that factor did not really benefit the district. That would be an error that in assessing a discretionary factor, and normally that also would require a remand unless, and I guess your answer is, maybe part of your answer I assume will be, you think even if prejudice is zeroed out as a matter of law, there is, the pioneer factors can't favor your opponents. So I assume that's part of your answer, but do you have an answer about why you think really the judge in Washington took a reasonable view of whether there was in fact prejudice to the district?
There's a reason we didn't really push prejudice in our brief, and we didn't push it hard below. I do think there's some prejudice. I think there's always some prejudice when you're upsetting finality. In this case, actually, I want to couch this in terms of how the employees argued it, because I think this is the most important thing that matters to us with regard to prejudice. The employees are arguing that there can't be prejudice because the record is already set. And I have two responses to that I think are important. Number one is that prejudice is not limited to whether memories have faded. That's one type of prejudice, whether you can still get your witnesses on the stand. But there's other kinds of prejudice that could come up in many, many cases, especially involving RIFs or collective bargaining scope and stuff like that, permitting, all of that. Beyond that, though, these cases can get remanded, and one of those cases already has. Marceau, the Marceau case has already been remanded by the Superior Court back to the OEA for additional fact finding. So there is always a risk of prejudice, and maybe we didn't, appreciate that in that case. But I don't think it's wrong to say that there is prejudice to the party. And I also think it's interesting. I don't think that the length of the delay, when you start talking about prejudice in those terms, should be measured in terms of when the RIF happened and how long litigation went on in the OEA. There's a reason why deadlines to appeal are very short. And the reason why is because once you're in litigation, everyone's on notice. So there's no reason to delay for months and months. And so I think that this court could, if you want to look at the length of the delay, it should look at how long it is the delay was in comparison to like what the deadline was. Like if the deadline was 1 week and it was 4 months, it's a longer delay than if the deadline was 60 days and it was 4 months. But like I said, we're not pushing prejudice hard in our brief. What we think is that they haven't shown a reason. This court's case law repeatedly says that excusable neglect is not available for run-of-the-mill situations. And yet we don't know the reason. We don't, even assuming that it was inadvertent, we don't know if it was a mistake in the law, which this court has said is not a good enough excuse. I think Pioneer says it's not a good enough excuse. Not knowing the rules is not a good enough excuse. Some excuses are okay, some aren't. And if they don't give an excuse, then the court can't conduct that assessment. So we think that Dorsey controls. Only after some explanation does the door open up for a balancing of the equities.
Let me ask you one other before you sit down question. What I find so unsatisfying about these cases is that we've got these other cases where the Superior Court judges rule to the contrary, and those cases are allowed to proceed. And to the extent that the folks involved in these 3 cases did want their lawyer to pursue an appeal, they've got to be left with the feeling of, this isn't fair. They get to go further and we're stuck now. Does that factor into this in any way at all when we look at the equities? I mean, your comment about we don't know whether they even wanted their lawyers to appeal makes me feel a little bit better about that, because who knows, maybe they don't care at all. But assuming they do care, what's the answer to that? Is there any mechanism for weighing that? I get it that discretionary rulings can go both ways. So, because one judge ruled this way and the other judge ruled the other isn't to say that either one of them is wrong. And that kind of negates the sense that they all should have come out the same way. But I'm sure you see my point. What's your response to that?
I do, and I think they all should have come out the same way. I mean, we believe that the excusable neglect finding is wrong as a matter of law, and we are hoping that this court will dispose of effectively, that this court's ruling will then lead us to disposing of all of these cases. Because what shouldn't happen is it shouldn't be that it just depends on the whim of the judge. I mean, this court says that excusable neglect has teeth. When you guys talk about the difference between good cause and excusable neglect, you're telling me, no, excusable neglect, it has teeth. But that's not the way the Superior Court judges are applying it. I would encourage this court to go back and look at their written decisions. And they're basically like, yeah, it's a good enough reason. I mean, I don't think it plays into the equities that some people got what they wanted and other people did not. I think this is probably the first time I've ever seen a situation where the same evidence went before different, like literally exactly the same evidence and briefing and attorneys in situation went before different judges. But I think what it shows more than anything is how loose of a standard good cause and excusable neglect are. And that is fine when it's just about docket management. But when it comes down to whether somebody can bring their appeal, it's yet another reason to think that this is not what the drafters could possibly have intended. Thank you.
Thank you, Ms. Johnson. Mr. Griffin, we'll hear from you for just a couple minutes.
Thank you, Your Honor. And I'm going to try to limit this rebuttal to 1 point unless there are further questions. And that is something that counsel just touched on about the context, and this being what she referred to as an appeal deadline, which isn't technically correct. It's not an appeal deadline. It's a petition to review deadline. And she suggested a number of times in her statements that the petition for review deadlines are different, and this is different than case management or docket management, and that because it's case initiating and it's coming out of a final agency decision, you should think about this differently. But your case law says that's not right, and the Supreme Court's case law says that's not right. So I would point you to Harrow decision from last year from the Supreme Court, which I believe was unanimous. That involved a final decision of the Merit Systems Protection Board. and the deadline for petitioning for review from the Federal Circuit. The Supreme Court held, again, I think it was unanimous, that is a non-jurisdictional deadline, A, and then B, that because it's a non-jurisdictional deadline, it's presumptively subject to tolling. Second, I would point you to the Beckler case, which is 2022, very similar. That involved a final administrative decision from it involved an IRS determination. And the deadline for petitioning for review in the tax court. Again, same result. The Supreme Court looked at it and said, this is non-jurisdictional and it's presumptively subject to being extended. And then, of course, there are more cases there. There's the Bowen case going all the way back to 1986 in the Supreme Court. That was about a Social Security disability determination and a review of that. And again, same result. It's a final agency decision. It's an initiating deadline for judicial review. The court said that can be extended. And then, of course, your own cases. The Brewer case, which is, of course, about the same deadline we're talking about here, the agency review deadline, Rule 1 deadline for petitioning to Superior Court. And then, of course, that relied on Mathis, which is the essentially identical deadline from Appellate Rule 15 for petitioning for review of an agency decision in this court. And in both of those, this court said that those deadlines can be extended. So we would contend that there is, you can't cabin excusable neglect or Civil Rule 6 to interim deadlines. They apply that rule and the equivalents in various parts of the federal rules and statutes absolutely can be extended for excusable neglect in this court, and the Supreme Court has said it over and over again.
Thank you, counsel. We appreciate your arguments today, and this case will be submitted. The third case on our calendar today is 24 TX 219 Commonwealth Land Title Insurance Company as subrogate G of its insured versus District of Columbia.
Good morning, Your Honors, and may it please the court. My name is Caroline Lee Goschel, and I represent the appellant Commonwealth Land Title Insurance Company as subrogate of its insured COM 2013 CCRE 12 K Street Northwest LLC.
I did not attempt to read the full name, so thank you. Can I just ask you either to pull the mic a little bit closer to you or to raise your voice just a little bit? Thank you.
And if it would please the court, I would like to reserve 3 minutes for rebuttals. COM 2013, and I won't try to say the full name out again, but is the
We've
owner
been
of
calling
a
it Commonwealth, so just for short, if you'd like to adopt that.
Commonwealth for the insurer, COM 2013 for the insured.
Got it.
COM 2013 is the owner of a leasehold interest in the subject property, which is 5 commercial condominium units on K Street. They are the owner pursuant to a leasehold deed of foreclosure that was recorded on September 30th, 2019. This leasehold deed was recorded following a foreclosure sale with a recorder of deeds, but only after the recorder of deeds had initially refused to record the leasehold deed of foreclosure because in its opinion, transfer taxes were due and owing on a August 2013 deed, which we'll get to in a moment.
So counsel, that just given the lateness of the hour, we're familiar with the facts and the procedural history, and I think we could just jump right into the legal issues.
Sure.
Which as I understand it is, it was this leasehold a taxable transfer? Should it have been recorded and subject to recordation tax, and should it have been subject to a transfer tax?
Correct, Your
And-
Honor.
And as I understand your argument is no, because this leasehold was created with the 2013 deed.
So the leasehold interest is a possessory interest that the Llano Armada, which is COM 2013's predecessor in interest to that interest. They prior to the 2013 deed owned all the fee simple title to the
Right, but
subject
at that
property.
point, they did not have a leasehold interest. They had a possessory interest that flowed with their ownership of the property in fee simple.
Correct, but the leasehold interest is a possessory interest.
I
subject to the terms of the driveways.
understand that, sure, there are all sorts of possessory interests. But the question is, as I see it, but you can tell me that I'm wrong, is sort of how did this leasehold interest come into being? Because if, I don't understand you to be arguing that or let me put it in the affirmative. Are you arguing, or do you agree that if Llano Armada had sold the property to Allegiance and then the next day signed a lease agreement to lease back the property for 117 years, would you agree that that is a recordable taxable transfer under DC law?
Because the possessory interest transferred to Allegiance, yes.
If you had a sale on one day and then a lease back on the next day, you would agree that so you agree that a leasehold interest for over 30 years is a transfer that has to be recorded and can be taxed
Only if,
generally.
only if it transfers from one person to another under the statute.
Okay, but in my hypothetical, it does.
Correct.
Okay, and so your argument is that this leasehold interest that now your client possesses was not a taxable transfer because it was not because it came into being with the signing of the deed. Is that your argument? That's
There-
what I understand your argument to be.
Yes, there is no transaction without the reservation of the leasehold interest, which allows Llano Armada to retain its possessory interest in the
Okay.
property.
But the possessory, and this gets back to my question, because it seems like really this isn't a statutory interpretation case, it's a property law case. And so if you're saying that the 2013 deed was the time at which you argue this possessory interest was retained and became a leasehold interest, right? Is that fair?
Correct.
Right? I just wonder under property law, whether that is possible, right? My understanding is that a lease is an agreement between a landlord and a tenant. And at the point where you're saying that the leasehold interest, the possessory interest in the form of a leasehold interest comes into being at the time when Llano Armada is selling the property to Allegiant. So Llano Armada cannot be a tenant at that point because they own the property, and Allegiant can't be the landlord at that point because they don't own the property, right? You have to have the sale first for people to be in the position to then enter the contractual arrangement that is the leasehold that then gives Llano Armada back some form of possessory interest. Why is that wrong?
Under traditional tenets of property law, your landowner's interest in the property if they own it in fee simple, all right and title and interest. There's no, they can alienate it and there's an unrestricted right of disposal. They
Do you
can
have
parse out.
any case that says that I can own property and divvy up my possessory interests in leases back to myself?
The Sears case in DC does acknowledge that you have various interests in property which can be.
I understand there's general statements about people who have fee simple having possessory interests in property, but my question is more specific. Do you have any case that says the owner of a property can lease the property back to themselves
Not in the District of Columbia.
anywhere in the country?
Well, part of the issue is we're interpreting under District of Columbia statute, so.
No, but I don't think we are, right? I think we're looking at black letter property law. And so if you have a case, I didn't see it in your brief. I saw very general statements about, well, people, we had a possessory interest before and we had a possessory interest after. And so, what's the difference? But I think there's a big difference. And I think leasehold interests as a possessory interest come into being by virtue of leases, right? Where the parties have different specific roles. One person is the owner, one person is the lessor, right? And at the point where Llano Armada owns the property, they cannot be the tenant, because I am unaware of any case that has ever said a property owner can lease property to themselves. Like the possessory interest that I have, I could split it up in lots of different ways. I could, say I'm Llano Armada, I could give Allegiant a life, I could retain a life estate in the property and give Allegiant the remainder interest. I could retain an estate for years in the property, both of which would give me much more control over the property, right? In addition to the possessory interest. But I am not aware of any case that says that I can, as the owner of a fee simple, divvy up my possessory interest into some sort of leasehold interest where I say, well, I don't own the property because I'm actually just a tenant leasing the property that I own.
So there's no, I cite no case in the brief, but I think the principles behind it, are well recognized. And I think
But what principles? I mean, the other principle that is out there is that leasehold interests are something called chattel real. Which is sort of, it's not real property, it's kind of adjacent to real property. But it's sort of treated as personal property, right? So it's not actually sort of the interest that you have in a fee simple. It's something that is distinct. And that's under DC, under our law in the DC code. We've said that in our case law. That's sort of black letter that leases are not actual real property. They're sort of this chattel real.
But we would submit that for purposes of statute, whether it's a lease or whether it's a fee interest, it's considered real property interest for purposes of the statute.
I get that, but I'm still struggling to see how your sort of general proposition that, you can have a possessory interest as the owner of the fee simple, and then subsequently, once you execute a lease, you can have a possessory interest pursuant to the lease, but I don't see how you can say that that possessory interest that arises under a lease is something that can be created by a deed that sells the property, even if the deed alludes to some sort of lease that's out there.
So we would submit that the Llano Armada retained its possessory interest, but the ground lease itself governs the terms of how they still hold possession after the transaction.
Can I drill down into that? I mean, assume that I think that the deed could have created some sort of possessory interest in the form of a leasehold. Why do you think this deed did? I mean, it doesn't say anything, and the government makes the argument of, well, if this is a lease for 117 years, it violates the statute of frauds.
Excuse me, could you repeat that?
The government, I think, makes the argument of, well, if the deed, the 2013 deed purports to convey or to retain, I guess, in your view, a leasehold interest in the property for 117 years, it violates the statute of frauds.
I don't know that it does because there's no transaction without the reservation. I mean, when,
Well, can
like,
I
just
ask you
like.
about that? Because, and this is more of a, Judge Easter was asking some questions about conceptual property law.
Right.
Mine is a little bit, my line of question, which relates to where Judge Easter was just touching, is more almost like contract interpretation and the interaction between the deed and the lease agreement. Assume that in theory, which I don't know to be true, but just assume for a moment in theory that you could be the owner of a property and you could say, I am selling it subject to a reservation. And the reservation is that I have a specified possessory interest for a particular period of time. And I'm not sure the word lease is a good use of that to describe what the relationship would be. And maybe I would specify all the nature and circumstances of my possessory interest in that deed. And that would be a, document that reserved, sold, fee simple, but reserved a set of possessory interests that might be similar to a lease. I don't know if you would want to call it a lease. I don't know. But assume you could do that if you did it clearly enough. Part of what I find difficult about this case is the deed refers to the ground, to the lease agreement, and the lease agreement is not at all consistent with that conceptualization of what happened. The lease agreement doesn't say, I mean, it has a little bit of language that refers to that reservation, but then the whole structure of it is that the owner in fee simple is giving back as lessor to the, but giving back to the occupant a lease interest. And so the whole structure of, if we're figuring out what the best way of interpreting the way the documents fit together, it seems like although there was passing reference to the idea of reserving possessory rights, so then you could think it's one transaction where only part of the overall bundle of rights is transmitted only one way. But the whole structure of the lease agreement is not that. It is instead, it says subject to a reservation, but then there are all these provisions where the agreement seems to say that the new owner is giving a bunch of rights back to the prior owner, and including features that seem very odd. If I am reserving a possessory interest, why do I then pay the person to whom I sold fee title rent for the possessory interest I retained? That doesn't make any sense. If that was my possessory interest and I didn't sell it to you, why would I pay rent for my right to exercise my reserved possessory interest? That seems not conceptually coherent.
I think the issue, so I think if we step back, so design center owner, and I think, it says, look at the transaction itself. What does everyone end up with after the transaction? As an owner, you have the right to enter into a leasehold, right? And that's the right that Lano Amada had prior to the transaction being entered into.
With a third party, for sure, right? And if Lano Armada entered into a lease with a third party and then sold it to Allegiant and said, well, we're selling it to you subject to this lease because we signed this lease and we don't want to breach the lease and be in breach of this lease and, get sued. So we're selling it to you subject to this encumbrance. They could do that. That's fine. Or as you say in design center, right? They could they could negotiate with their tenant, cancel the lease and then say, we're selling you all of our fee simple interest in this property, right? That's what happened. That was a sale of the entire interest. But here, you purport to say we're reserving something by virtue of a leasehold, but a leasehold by definition is a transfer, right? It is a transfer of the possessory interest from the landlord to the owner, right? Which becomes Allegiant and to the tenant. And as Judge McLeese said, you have this lease that says, here's the lease agreement says, here's the transfer. It's all in this document. It's all in this document. And the document has an integration clause saying this lease contains the entire understanding between the ground lessor and the ground lessee.
I don't know that I agree that a leasehold interest necessarily, at least in this case, involves a transfer. I mean, it involves.
I mean,
definitely-
that's black letter. I can cite you like 10 different treatises that say a leasehold is a transfer of a property interest.
But I mean, if we're relying on treatises, then it also, the treatises also say that you can devise a property in any way and split it up, carve it out
But
however
they,
you would like.
no treatise that I have found, and I found no case, says that what you can divide up is a leasehold. I mean, nobody says that you can retain a leasehold interest because you have to have a lease with a landlord who owns the property who isn't you. So it's not something that you can retain, right? You need to have another party outside of you owning the property before you can have a leasehold with them.
I mean, as.
I understand that
right.
you disagree. I haven't seen any support for your argument
know,
that that
what-
is not true.
This all comes down to, for me, and maybe you can tell me why I'm wrong, because it seems to me the simple way to look at this case is that a lease was executed. There was this first transfer with the reservation that we've been talking about. And then there was a lease, right? And I say then, but maybe it was the same day. It was almost simultaneous. Is that correct?
It was simultaneous.
Yes, it was simultaneous and no transfer or recordation tax was paid on that lease. And now we're in the present or whatever year this occurred and there was the foreclosure and an effort to record a lease and OTR said, nope, wait, you didn't pay the past taxes. There was no past tax paid on this lease. I mean, why isn't the answer you didn't pay at the time there was this lease that memorialized what was in that agreement with the reservation, and now you owe it? Why isn't that the answer to this? Is that overly simplistic? Or am I assigning to the agency some reasoning that wasn't theirs? Maybe that's your answer. But it just seems to me that at some point in time, and you've said simultaneous with this other transfer, there was a lease. It was for more than 30 years. Tax was owed on it. It never got paid. And before you can record or could record this new transfer to the entity that came to possess it through foreclosure, that old tax has to be paid. Kind of end of discussion. I don't know what the problem is. And I find myself not needing to go through all of these mind-boggling thoughts about whether you can actually reserve to yourself lease rights without having a lease. There was a lease.
Well, part of the issue, I think, as this goes into the next argument, excuse me, the next argument with respect to the statute of limitations issue, if that's correct, where the leasehold interest was required to be recorded and taxes paid upon it, that interest was disclosed on the face of the 2013 deed. The recorder.
But it wasn't, the length of the lease wasn't. I mean, there was some reference to the reservation of this interest. But as I understand the record, nothing said that this was a lease of the length of time that triggers the need to pay this tax.
But
Is
part
that
of-
wrong?
That's not, well, you're correct in the recitation of the facts, but DC statute presumes that all interest within a deed are taxable. And so if that's the case, at least that raises if the reservation, the leasehold interest was indeed taxable, that raises the question, well, why didn't the recorder tax it at that time?
But what
Or
I'm
at least
saying,
make-
it's not
raise
the
inquiry.
reservation, it was taxable, it was that simultaneous lease. Why isn't that the right answer?
Because but the ground lease is also referenced within the deed.
Well, it's referenced in some respect, but does the deed say for how long the lease would be?
The deed does not say how long.
Well, that's my point. It doesn't. So nothing told OTR that this is the kind of lease that's taxable. For all OTR knew, and tell me if I'm wrong, for all OTR knew upon reading the deed, this was a 2-year lease, not taxable.
Well, I would say on the first part, with respect to ground leases specifically, I think in design center owner, they acknowledges generally ground leases are often, the terms are for decades. But I think the other issue is that the presumption under DC statute is that every interest within a deed is subject to taxation.
Because
And if-
just as a hypothetical on the statute of limitation side of it, assume that I buy a property or I sell a property, I buy a property. And the deed that relates to the transaction says that, the such and such a property was sold at such and such an amount. And also has a paragraph in it that says there are also other related real estate transactions. Other related sales of property. But didn't say what they were, or didn't say anything about them. And that was submitted, and recordation and recordation fees, and I'm forgetting the other term,
Transfer and recordation.
transfer and
yes.
recordation fees were paid only with respect to the amount of that specified transaction. Would you say that OTR was on notice that, well, there's reference to some other potentially taxable event that occurred in this deed? So the statute runs, OTR has 3 years to go figure out what those taxable events were. And if they don't figure it out in 3 years, the statute runs. Is that how you would view that hypothetical? And
Well,
if you wouldn't view it that way, how would you distinguish it from our setting?
I think your hypothetical, I think it's still it's a little broad and a little bit vague. So so I'm having a little bit of, it's hard to like hammer down exactly how I would distinguish mine from yours. But what I would say is that here there is an express reference to a ground lease. There was an express reference to a reservation of a leasehold interest. In a deed that is otherwise transferring all right, title, and interest to Allegiance.
Well,
So,
except that, I mean, there's also the return that was filed with the deed that said expressly that the interest transferred was a fee interest. And it was 100% of this fee interest that was transferred, which seems to cut entirely against your argument that something, was reserved to you, some part of, the fee interest. If your argument is, well, within my fee interest, before we sold it, we had some ability to create some leasehold interest, and we withheld that, then that would seem to be, some percent of the 100% of the fee interest that you're then saying you transfer.
well,
So, I mean, I know you want to rely entirely on this statutory presumption, but it seems like a pretty thin reed where you've got a deed that doesn't say, for all we know, it's not just as Judge Thompson says that it's a 2-year lease back. It could be a 30-day lease back, right? Just for whatever reason, for convenience, because, they need to, they've agreed to transfer some improvements or, for whatever reason. But we have zero information from the deed as to how long this leasehold provision is. And the only documents that are filed with the Office of Taxation is that we're conveying everything, and it's the fee simple.
well, assuming that there is no, the leasehold interest was not considered to be reserved or retained by Llano Armada, then there is a transfer. I mean, because it's, as Your Honor recognized earlier, if it's considered a chattel real for purposes of this transaction, it's still 100% fee transfer in terms of what the interest that's being transferred by.
Yes, but there's
the deed.
nothing in here to indicate that it is, the kind of leasehold, over 30 years that would be subject to taxation, right? If it had said, maybe, we're selling this property, except, what's the language? Less than except, a leasehold interest of 117 years, maybe you would have a better case. But it doesn't say anything.
Part of the other issue is like, there's no, like, so say if you're a standard ground lease, or your standard like memorandum of a ground lease type situation where you go to the recorder of deeds and you record that, there's no requirement or guidelines that within the statutes, or as far as I've seen the municipal code, in terms of what are you supposed to put in the deed or document that you're recording to evidence that this is what you need to
Well,
put in.
this is
with
a
respect to-
I mean, now we're on the statute of limitations issue, right? And so if we think that in fact, that, that there was a sale of property with a lease back, and the lease back was a recordable taxable event, right? Then what should have been filed is, as Judge Thompson indicated, should have been the lease. That should have been, recorded. That should have been recorded. And, to your argument of, well, we don't know what to file, we don't know what to record. Well, you record the lease.
Well, in terms of,
And if we're talking about statute of limitations and we're talking about, well, did you put the OTR on notice? Then I'm just having a hard time seeing what would have put OTR on notice, since you didn't file the lease with some sort of just informational return, and you didn't reference the type of lease that it was. And you say in the return that you filed, well, we just sold 100% of this fee simple.
so with respect to the return, I think what I'm struggling with is there's no guidelines. The recorder asks for what it wants when accepting a document or a deed for recordation, and it can refuse to accept. It can ask for more information, or it can choose to or it can choose to proceed and accept the document.
Right, and there's no reason here that the recorder of deeds would have thought to reject this, because it sees, well, they filed a deed for a sale and they say that this is 100%, they've sold 100% of their interest in the property.
So is there, I guess what I'm trying to understand is then, I don't think there's any support within the statutes or within the case law saying that the recorder can make the assumption that when it sees a ground lease in the express reference to a ground lease in a deed, that the automatic assumption is it's not a reportable taxable interest. Because I think the presumption in the statute is that it's.
I understand you're
Right.
relying on the presumption. I'm saying I don't think the presumption gets you all the way there.
And part of the other issue is that with respect to when you're considering deeds for recordation, you do look at the other documents that have been filed. There was a deed of trust filed the day after the 2013 deed that was accepted. Presumably, they reviewed the terms. The deed that was recorded the day before. To me, if the recorder was able to make the inquiry at some point, but I don't know why the recorder didn't make the inquiry earlier. And part of the other issue for me is there should be, to me, the return submitted for the 2013 deed was intended to encapsulate everything that was contained within that deed. It's not a long deed. You can look at and examine the interests that are purporting to be conveyed therein. So to me that there must be some examination and inquiry, because that's incumbent upon the taxing authority to do that. That apparently that wasn't done, at least in 2013, but was done subsequently. So to me that should have at least, I don't know that the recorder held up its end of its responsibilities under under Sunbelt or the statutes in terms of what it's supposed to do when examining the deed for purposes of triggering the statute of limitations.
Thank you, counsel. I think we have your argument. We'll give you a couple of minutes for rebuttal.
Good afternoon, and may it please the court. Carl Schifferle for the District of Columbia. In the district, a lease for a term of at least 30 years must be recorded and is taxable. And here, the 2013 ground lease between the lessor, Allegiance, and the lessee, Llano Armato, is taxable on its face, as it is for a term greater than 30 years. And as Judge McLeese, you noted, this looks like and operates just like a standard lease, even if there's some hypothetical way that perhaps an interest could have been reserved. We disagree with that, but this is clearly just your standard ground lease. And in response to Judge Thompson, your question, I think that ends the matter. This is a ground lease, leased for more than 30 years. It had to be recorded. Taxes had to be paid on it. It wasn't at the time. And that should be the end of the case.
Can I just ask you, though, you say you disagree with the idea that it's possible in if this, you didn't say exactly this, but I understand you to be saying you don't think it's possible, no matter how the terms are used, to have in a single transaction, an owner, someone who completely owns a piece of property, to sell title, to transfer title and reserve a possessory interest that would be similar in its consequences to a lease. And so I want to make sure I understand what you think. So let's say I own property and I want to sell it to you. And the way I want to, in part, I want to reserve my possessory interest. So I say, I'm giving you title, and however, I'm reserving to my, I'm not transferring a possessory interest that I have right now. And I'm going to keep it for 117 years, at the end of which I won't have it anymore. And in the interim, as the consideration for that partial transfer of my set of interests, you're going to pay me a bunch of money up front, and I'm going to pay you money spread out over time. We're not going to call it rent. I'm not going to do any of those things. And there may be other provisions in this lease agreement that wouldn't encapsulate, but the basic structure, that sort of is like a lease. But it's just not 100% obvious to me why that can't be done in a single transaction that says, I own it all. I'm giving fee title to you. You're giving me a bunch of money. I get the right to stay on it for 117 years. I keep the right that I already had, but limited it. So I'm only going to, right now I have indefinite right to stay in it forever, but I'm going to limit myself to 117 years and give you the rest of the possessory interest. And then we're going to exchange some, some money up front and some payments back and forth. Why is it that you couldn't? I don't think you should call it a lease, because that gets people, I don't mean to say confused, but that triggers concepts that may not fit well. But could I do what I just described if I don't call it a lease? Or do you think I can't do that in one transaction?
Because I think you're just using a different term to describe what is in fact and function a lease. I don't know how it would be distinct from a lease. You have rental payments. You're just not calling it a lease. There's no authority, and Judge Easterly, this is your point, that the seller of property can reserve what is in effect a leasehold interest or anything equivalent.
Is there authority that you can't do that?
Well, I think it's just inconsistent with the basic notion of what a lease is, and I guess I'm tying it back.
I'm not going to call it a lease, and you're saying in substance it's like a lease, and maybe it isn't, but I just don't know. But I just am curious whether there's case law that zeroes in. I mean, each side is kind of citing general principles about why this doesn't work or does work. Like, a lease requires an owner, and you can sell your part of your bundle and not the rest of it. And so there are generalities, but I'm just unsure whether some of those generalities do or don't apply depending on how you structure and use terminology to describe what you're doing. And I take it that you're not. It's not like you're aware that there's something that says it's just conceptually impossible and leave aside, let's take half of it, leave aside the payment back and forth. Let's imagine that instead I say, I want to sell it to you, except I own it in its entirety. I'm selling you every interest I have, except I'm retaining the right that I already have to live in it, for the next 117 years. Are you saying that can't be done? That just can't be done in one transaction. It's not possible to do that.
That's right, that there's no authority. I mean,
Either way,
well,
on whether you can or can't do that in concretely.
You think that someone could sell a property and reserve a life estate in the property or an estate for years? Because I think that they probably could do that. I just think that the effect of doing that is quite different than being a landlord. Having a landlord-tenant relationship. You then have the life estate, and I haven't sort of spun out sort of what all the legal consequences are, but presumably Allegiant didn't want Llano Armada to have a life estate or an estate for years, because they had less control over the property. As a landlord, they own it, right? And I don't know whether they could borrow against the reversionary interest, but presumably that's a less valuable asset than owning it and leasing it out. They didn't want to do that. There were other things that they could have done, right? Whereby maybe this, simultaneous reservation and sale could have happened. I think there are other property law constructs available. But, so I'm curious to hear you say that you don't think, that Llano Armato could have reserved some sort of estate possessory interest in fee simple terms. And I'll stop talking and let you answer.
Yeah, well, I want to be clear that, right, that I'm not talking sort of all across the board, that some sort of reservation of some sort of interest isn't possible through a deed. It's just something that is either, as in this case, clearly a lease, structured as a lease, entitled ground lease, has rent payments. I mean, that clearly can't take it out of the requirement to record and pay taxes on it. And even if it's tried to construct something that looks like or isn't called a lease, but in fact functions as a lease, I want to make sure that that is taxable too. And the requirements of recordation also applies, because we don't want to create a situation where we have these sale leaseback transactions, which are taxable, but through some sort of clever artifice, not calling it a lease, suddenly renders it not subject to recordation and taxation. So that was my concern there. And so, we have the facts of this particular case before us, and I think it is quite clear that what happened here was a lease that is taxable and recordable, because the purported reservation simply can't operate the way the taxpayer insists. There has to be, in order for a lease, a landlord, a tenant, payment of consideration for a specified term. That could not happen in this case until Allegiance acquired fee title to the property and then leased that back to Llano Armato, again, for a specified term. It would also lead to absurd results if the taxpayer's position here were adopted. And I think we touched on the court, Judge Easterly, you touched on this earlier. If the sale if the lease had been entered into a day after the sale, I think the concession here from my friend on the other side is that ground lease 1 day later would be taxable, but that would lead to an absurd result of why, which is in essence virtually identical transactions, would be taxed and treated differently under the recordation and tax statutes. There's also the concern as well, is that would mean that, again, if taxpayer is correct, that if there's some possessory interest that is held prior to the transaction and some possessory interest that's held after the transaction, that's not taxable, then again, what the statute requires could be easily circumvented by the parties just entering into a short-term lease, a day, a month, and then entering into the long-term lease and making the same argument as is advanced here, that there was no sort of transfer of possessory interest because that possessory interest was pre-existing.
Isn't that different? Sorry, it just seems to me if they entered into a short-term lease, that's like a possessory interest of a limited period of time, and then they're getting more if they then jump from the short-term lease to the long-term lease. But here, what they're saying is they had more, they had the whole fee simple, and they were just holding back this lesser thing of they're purporting to hold back this lesser thing of this just leasehold interests. I didn't quite follow your argument that this could lead to short-term leases going to long-term leases if we agreed with their argument that it is theoretically possible that they could reserve a leasehold interest in the deed and that was what was done in this case.
Yeah, I think it's because their argument doesn't necessarily hinge on there being a leasehold interest. Their argument does retreat to the fact, and I think perhaps conceding that it's hard to imagine how they did have a pre-existing leasehold interest. And they say, well, we had a pre-existing possessory interest, and to use that as a mechanism, again, to avoid the recordation and transfer.
Can I ask you about your other absurdity? Maybe you had more than two, but one of the other absurdities. that you perceive, which would be if it's conceded by your opponent that if this had been, there had been no reservation and then there was a lease back the next day, that both, there'd be two separate transactions, both taxable. And it would be absurd to have the form of the transaction dictate the amount of the tax. I'm not quite sure. I mean, I think it would be absurd if that was the law to do it in two steps rather than one, but that's, for example, let's take a straightforward deed. Let's say I own, a 20-acre property and I sell it, all of it to you on one day. And then the next day you sell me 10 acres back. So the net of it is I sell you, 10 of the 20 acres. Well, if I'm silly enough to structure the transaction that way, we're gonna have to pay taxes going both directions, I assume, which means probably shouldn't structure the transaction that way, but it's not absurd to think that if I am smart enough not to structure the transaction that way, I only have to pay, a transfer tax on a 10-acre transfer rather than on a 30-acre transfer. So I'm not quite sure it would be absurd to have those distinctions be how the tax operates. It more would mean people should structure their transactions sensibly in light of the formalities that the tax laws impose.
True, but what happens in your example is that there's an argument, not that taxes shouldn't have been paid, but that taxes should have only been paid once because the transactions were close enough in time. What is
No, I think that's analogous. I think their argument is what happened really is that shifting back to this case, I think their argument is what happened really is we only sold half of, a portion of the interest. And instead of thinking of it as all of it being sent over to the new purchaser and then part of the leasehold interest being sent back, so you tax all of that, you should instead, you should instead conceptualize it as one transaction where only half of the overall value, I don't mean half mathematically, but half of the overall value is transferred. And I just don't think it's absurd. If the law could be that way, and it could be that if you were, instead you didn't do it that way, assuming you could do it that way and it were done here, both assumptions that are debated, I know, it wouldn't be that odd that the tax laws might distinguish between those two. And it just means people ought to structure their transactions sensibly.
Yeah, I mean, I do take the point, but I think the fact here would mean that the ground lease, what is on its face, taxable, recordable by the plain language of the recordation and transfer statutes, would escape taxation entirely. And I think that is a different scenario. What the taxpayer is attempting to do here is write into the statute some new exemption for sales leaseback transactions, and that's simply not permissible. The statutory exemptions do not contain such an exemption. They can't write it into the statute, and the statute has to provide an exception if one is going to be available.
Does OTR have some obligation to ask some questions and investigate when it sees in a deed a mention of a reservation, for example, that might just turn out to be a long-term lease that's taxable? I mean, can it just, say what I said to your opponent? You didn't say that explicitly, so end of discussion. Doesn't it have to have an obligation to ask some questions and figure out what this thing is that's being reserved or transferred?
There may be an obligation that arises at some point, Judge Thompson, but you would have to start with the requirement of filing a return in the first place, because it is, unless that return is filed, the tax may be assessed at any time. So we have to start there with whether there's even a return. And in this case, we argue there was not. There was neither a return form indicating that a leasehold interest had been transferred, or even the underlying deed or document that was the ground lease. Both are required in order for there to be a return. After all, it is the record.
Do we have to really focus on separate returns? I mean, what if there had just been the one return in this case and they had filed both the deed and the ground lease with the return, making it very clear, hey, this is an 117-year ground lease that is clearly subject to the over 30-year ground lease taxation recordation provisions?
Yeah, I didn't mean to suggest there needed to be two tax return forms.
Okay.
It could be that the form indicates both the fee interest and the leasehold interest are being transferred and includes both the deed and the ground lease as an attachment, even if it's just a single form, that would be fine, but that's not what we have in this particular case. We have a tax return form that indicates only 100% fee interest being transferred. The box for leasehold or other interest is not checked. There's nothing on the face of the deed. If you go beyond the return form, nothing on the face of the deed to indicate that there is a taxable leasehold interest that's part of the deed, because as Judge Thompson, I think you mentioned, there's nothing in the deed itself that reflects a term of this leasehold interest, what period of years. And so there's nothing to indicate whatever leasehold interest might be reserved, that it is a taxable leasehold interest because it's
Remind me
along.
how this comes to light eventually? I mean, I know that the property is sold a couple of times and someone tries to record something, and at that point, the recorder of deeds says, wait a second, there's outstanding taxes. But what is it that they file that puts the recorder of deeds on notice? Is it the leasehold itself?
So yes, when there's the foreclosure, when Llano Armada defaults on the deed of trust, and then it's that leasehold interest that Llano Armada has is sold. The purchaser, COM13, then seeks to record, the ground lease that it has purchased. It's at that point, the
So
recorder of
it's
deeds.
the ground lease that puts the recorder of deeds on notice.
Correct.
Is this the case where in order to resolve it, we need to accord some deference to OTR in some way? And if your answer is yes, what are we deferring to? Is it a statutory interpretation or what is it?
So if necessary, yes, we still insist that OTR would get deference if it's necessary to resolve an ambiguity in the statute or the regulations. We don't think there's any such ambiguity here. We think the plain language of the statute dictates the result in this case.
But why I'm just picking up on Judge Thompson's question, like what triggers deference here? It seems like everybody agrees that a transfer, that a ground lease of over 30 years is a real property interest, and that when it is transferred, that is a taxable recordable event. Like that's just unambiguous. And it's really this question of either property law of whether, a leasehold can be retained at the time of a sale, or sort of a contractual kind of factual question of what is this thing that is the leasehold? And I'm just wondering, like, do we need to get into deference? Is this something that, or either of those questions on property law or how to interpret this ground lease agreement, something that we would ever defer to OTR on? Can we bypass questions about Chevron and Loper Bright and?
Well, again, we don't think the court has to apply deference because it can apply this plain language and other tools of statutory interpretation and reach the result. But I do think this is more than just sort of common law principles of property law. True.
And contract, right? I mean,
and
it's sort of
contract.
what is this document that is the ground lease, right?
Sure.
Seems to say, hey, we are transferring a possessory tenancy to you, right? That's what the ground lease says, which would then seem to be inconsistent with this argument that, wait, the deed retained a possessory interest in the form of a leasehold.
Right. And I do agree with all that, but there's also the overlay of ultimately this is a question of taxation and recordation. So it's not as though the council needs to track every principle of common law property or every contract law principle. It is a taxation and recordation statute. And I think that's where you sort of ultimately end the inquiry. Is this the sort of thing that the council intended to require recordation and taxation? There are presumptions, for example, in the statute that do make clear that if there's sort of a doubt about it, it has to be recorded. And if it's a doubt about whether there's a transfer, again, the presumption is it is a transfer. And so you are still applying the statute, and that's where OTR would get deference. because it is ultimately a question of what the taxation recordation statutes require. And I think in this particular case, you have OTR through the declaration of the Recorder of Deeds explaining the analysis, how it applied the relevant statutes to reach the result it did. We also referenced OTR's tax notice 2024-02, which again describes in some level of detail how OTR treats ground lease creations and assignments and how they are taxed. So it spells out OTR's position, which we do believe is entitled to deference as a reasonable interpretation of the underlying taxation and recordation statutes. We don't think the court needs to get to the issue of deference. I think it's, you know, we can get there without deference. But I wouldn't disclaim reliance upon it. I did want to say just a couple more words on the statute of limitations issue. And to answer specifically, Judge Thompson, your question, not only does the deed not indicate that this is a taxable leasehold interest to the extent it can reserve a leasehold interest, because it doesn't indicate the term of the lease. It also, there's no indication of what the consideration is.
Well, and to the contrary, it seems designed to be an assertion that it wasn't taxable because there was no leasehold transferred. The way it's referred to in the deed is that it was a retained interest. And so if you're looking at what the deed says only, assuming you could retain an interest and it wouldn't be a taxable event, debatable assumptions, then you're telling the Recorder of Deeds, here's a non-taxable fact. I retained some interest. That's what the deed seems to say. So it's not only, and then one could look at it, and if you look at it and say, maybe that would have been a non-taxable event if they could have done that, and they did do it, but it isn't what they did. What they actually did was have a complete lease agreement, which was taxable. So one could say, rather than putting the Recorder of Deeds on notice, the language in the deed is what it was intended to. One could infer, but it operates to imply that there was no taxable event.
I guess I just don't see that, because what the form indicates, the tax return form indicates, is that there's not a leasehold interest. The ground lease
Focus
is
on the deed. You're talking about the form right now.
Oh.
What you're saying is the form. I was talking
Oh.
about the deed.
And
Okay.
I thought it was a friendly question,
Oh.
right? To say if the deed is saying, actually, this is a retained interest, that would suggest further, this is a non-taxable event and dissuade OTR from expending resources on figuring out, looking any further. Because first of all, there's this reference to a lease that doesn't say it's an over 30-year lease. And also it's purported to be this interest that's being retained, not being sold. And so there is no transfer that would be subject to taxation, at least according to the representation in the deed, whether or not that's correct, but it's for statute of limitations purposes.
Yes, sorry, and I think I was mixing up two things. One is that there's no reason to believe when you read the form and the deed together that there is a taxable event in terms of the ground lease. So that's one problem. Moving on to the second problem, which is even if you assume that there was, an attempt to file a return as to the lease, the problem there is that there's not the information that you would need in order to calculate what the tax is, because there was consideration as part of the ground lease, the rental payments, and that is entirely admitted because the ground lease wasn't recorded and because, again, it's not reported through the tax return, that particular consideration. And so for both, I was trying to go to both, the fact it was taxable as well as how would you even compute the tax. And both of those would be fatal to the fact that a return was filed. It certainly would not trigger the statute of limitations. And just a final point on the statute of limitations, the trial court did recognize that this was not the sort of honest mistake that might excuse sort of or allow the statute of limitations to run, but this was a situation where the taxpayers took great efforts to avoid taxation. And so I think when you take all those facts and circumstances into account, the statute of limitations did not run.
Thank you, counsel.
Thank you.
Ms. Lee Gosel will give you just a few minutes.
I'll be brief. On the last point that my friend on the other side mentioned, that this was not sort of honest mistake. I mean, we have, and I think Design Center refers to this, you have a large transaction, there's lawyers, there's accountants involved. The party to the transaction can rely on its lawyers and tax folks to, rely on their advice as to how much tax they're supposed to pay. There was nothing in the record that supported the judge's finding that this was not an honest mistake. With respect to the question of the leasehold interest, I go back to Judge McLeese's questioning. There isn't really authority on either way in terms of like whether you can reserve yourself a possessory or leasehold interest. But if you go back to the principal tenets of property law, an owner of a fee simple interest is supposed to be able to carve out however they would like.
Well, I
Now-
think that there's lots of law that saying that you can reserve a possessory interest when you sell property. I mean, I would think that there, you can sell property subject to a life estate. You can sell property subject to an estate of years. I don't think that is subject to dispute. I think the question is, can you sell property and retain a leasehold interest? And, I don't think there's any case law to say that you can, or our black letter law to say that you can. And the fact that a leasehold interest is created by virtue of a lease, which is a transfer of a possessory interest from a landlord to a tenant, makes it very hard to understand how someone who is selling the property as the owner could be transferring or withholding a tenancy interest in the property that they own. I conceptually have a very hard time understanding that.
Understood, and I went through that at length in my earlier comments. But I would just say, I think the concern I would have here is that you have tax and recordation statutes that premise the imposition of taxes on the occurrence of a transfer. If you have parties who are trying to retain to themselves an interest in the property, including a possessory interest, I think you start wading into territory. Well, what is this not? Is this not interest that I've retained to myself? Is ROD going to consider this to be a transfer from one person to another, even though at the end of the transaction, I still have the same.
But you agree
interest?
that after a sale, right, I mean, the next day you can enter into the leasehold agreement where the new owner transfers the possessory interest back to the prior owner,
Well,
right?
and this goes back to Judge McLeese's comments regarding how people structure their transactions. I mean, you could do that. The possessory interest transfers to the new owner.
I guess I just don't understand, like, if you separate it out in time like that, and put a day in between, then isn't that exactly what's happening at the same time? But it's just that the two transfers are happening at lightning speed, right? There's still two transfers. And it doesn't matter that there's a day between them or a nanosecond between them. It's still two transfers.
I don't know that. Well, I don't know if I agree with that construct just because there was never
I mean, you
we
did
contend there is a
concede that if
transfer.
there's a day between them, that it's two transfers.
because there is a transfer of the possessory interest at that point.
Right,
But there wasn't one here. I guess that's,
yes.
yeah,
Yeah.
that's what we contend.
Right.
So, yeah. Thank you. I see that I'm out of time.
Thank you, counsel. We appreciate your arguments. We appreciate you staying with us into the afternoon. Again, sorry for the delay getting started. This case will be submitted and we stand adjourned.